Titles in Commerce, featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Welcome, everyone, to this Tuesday, January 26th edition of Money, Banking, and Trust by Moving Titles in Commerce. I'm your host, Christian Walters. We'll continue on our discussion with the trust as we've been talking along the Gilbert's Law Summary line, Trust by Edward C. Halbach, Jr. So it's all about trust. The gentleman there had asked the question earlier. I'd like to explain a little more that, everything I've been doing in the past, I really realized that it's all about debtor-creditor, and I realized that we were doing everything all wrong and backwards. So I've really changed my whole focus. Everything is completely different now. I'm gearing everything towards trust, which really makes better sense, really, because once you get into trust and study the trust, you find out that a lot of everything that didn't jive under debtor-creditor all of a sudden makes sense under trust. So I'm switching everything into the trust mode, and instead of doing debtor-creditor, I'm going to stick with trust. Going to lives, eat, and sleep trust, really. And for those of you who haven't been in it since we started switching over back in November last year, November, December, and January here, I would suggest that you go back and check out my website, which is movingtitles.com, and keep an update on that site because I will be putting different information on there, and I'm gearing that site solely towards trust. And like I said, I'm leaving the debtor-creditor behind. Not that I might never use it as a hybrid, but it's really that you can't get a remedy. It's not as debtor-creditor relationship. It's really as a secured party creditor. You can't get a remedy under that. The remedy's in trust, and it's commerce through trust and equity. So in a trust, you are the lender of an asset held in special deposit, and if you don't express the trust, you're the debtor under the UCC debtor-creditor relationship, and you'd have to bond the case, and the bond is really with the trust. And a bond is a trust in a trust relationship. So here we've been talking about trust all along, but we've been construing it along with everybody else because we never expressed it as a trust. So they're construing it and getting us to function under debtor more than UCC, the except for value, return for value, and everything like that. I mean, we have things in trust that I've discovered that are similar to those, although I wouldn't call them except for value. And it's all really explained in the Gilbert's Law Summaries as a basic primer for statutory trust, which is really the black, but the trust that we're really talking about is the white's trust, which is opposite the black. But if I teach what the black is, you'll know the white by sight. So to give an example, the except for value, return for value under debtor-creditor, which in my opinion and the evidence that I've discovered, which is not exactly just strictly opinion, but based on the evidence I've discovered, what we were doing by accepting for value, returning for value, was creating a lien, which was under UCC, which was a negotiable instrument, and anything under negotiable instrument law is debtor-creditor, and you're creating a debt. And debt is what we're using as money in the system today, and it's functioning as money, it's functioning as credit, and credit's what we use as money. So these liens that we're creating, that we're putting our signature to by an unqualified signature, which is really the rule of the signature is what I go by in expressing the trust, but since we're not expressing it as a trust, we're creating a lien, so what we're just doing is making a bigger debt to pay another debt. So we got double debt upon debt, so they love us for that, because we're creating more money for them to utilize. And here all along, we thought we were getting some kind of set-off, and we weren't even touching the set-off in the private side. We weren't even doing a discharge on the public side. We were just adding to the debt, the public debt. So it's my conclusion that we no longer do any except for value, return for value, because there's a better route, and that better route is 180 degrees the other direction, and I think that's what they were using to lead us on down the path by giving us a few bones here and there of successes, because I don't know anyone at all who can claim a 100% success rate on any methodology that they use out there, no matter what it was from A to Z, whether it's litigation, whether it's redemption, whether it's OID methodology or any of it. Everybody has a success rate of about the same. Now that made me wonder why. Why is it that it looks like you could throw a garbage lid in there and get a remedy to some degree, when somebody could take somebody's success, duplicate it exactly the same way, and turn around and they don't get a success? That made me wonder why. And then with this trust stuff that I was studying all along, because the title of the show is Money, Banking, and Trust, by Moving Titles and Commerce, the more I studied trust, the more my eyes got opened up to the fact that, hey, it's been trust all along. Now, all of us have been talking about trust, but we've been talking about trust only in as a protection method for protecting assets. So that was just a device for protecting the assets of the debtor from the creditor attacking him. So we want to put it into trust. Now, I'm treating trust solely as not a defense move, but solely as an offense move. And now I'm finding out that that's what they've been coming at us with all along. It just looked like debtor-creditor because the relationships, debtor-creditor relationship and trust relationship, are so closely related, they look somewhere on the surface, but you got to dig down a little bit in there and you'll find out that they are different. And when you find out about trust, what trusts are operating in a solely different world, in equity, and here we thought it was admiralty all along, which is nothing more than debtor-creditor, and they were taking you into admiralty to enforce on a breach of contract, but really there can't be any contracts because there is no money. You can't give a value for consideration. But under trust, you don't have to give a value of anything. It's a thing. Whatever the thing is, the res, that's what's put into the trust. That's the principle. That's the thing. It's the property. So that alone should tell us something. The fact that most of us were getting, hold on, I'm going to mute everybody out, so and then you have to press *5 to get back in, I think. All right, we're back. So the debtor-creditor relationship is so closely related to the trust that you really have to dig down into it a little bit. But the trust operates solely under equity, and that's where the trust power is. And that was like the admiralty coming at you under debtor-creditor, which was operating and taking you into equity, and then for the enforcement. And then you got a breach of the duty under the equity, because equity is going to compel you to do the duty. When you didn't do the duty, then you wound up in jail or you owed the debt foreclosed. But it's really the same as the trust. So what we thought was admiralty or debtor-creditor was really trust. Because if it walks like a duck, talks like a duck, it's a duck. And we're talking about the actions of a trust. It walks like a trust, talks like a trust, and it's a trust. So that's the whole secret. No parties in the trust need to know or understand they're forming a trust, including the grantor, the trustee, or the beneficiary. But that does not negate the fact that a trust was formed. If the law recognizes a trust, then there is a trust. And as long as I have the elements, the intent, the purpose, the parties, the specific res, and one of the methods of formation, then I have a trust. And as long as I can prove that, after I've made a claim that it's a trust, then I have standing to come in and make a claim as, say, the beneficiary and say that the trustee didn't make a payment or didn't make a disbursement. So then the burden of proof, after I made a prima facie case, shifts to the trustee, and a court of equity assumes that the trustee is guilty. That's exactly what they were doing when they took you from admiralty into equity, and the same thing happened there. So the strength comes in equity, where the court is going to assume that the trustee is guilty, didn't make a payment, and the only way that the trustee can prove that he's innocent is that if he has a record that he made a payment, period. And the only thing the court wants to know at that point is, when are you going to make a payment? If you're not going to make a payment, then you're in contempt. So there's where the power of the trust comes in. It's in equity. So here along, we were talking about a trust operating in equity with a different face mask, thinking it was debtor-creditor or admiralty or whatever, and it was not. And they're getting us tricked to come under debtor-creditor under UCC, creating these negotiable instruments, thinking we're going to do a set-off or discharge, and there's no way possible. So how does one get a remedy then? Even though the remedy is not in the debtor-creditor relationship as the secured party creditor, the remedy is in trust. It's commerce through trust, as I said before. It's not knowing who you are as secured party creditor. It's got nothing to do with that. That's going the opposite direction. Knowing who you are as grantor is the important part. If you're the grantor of the trust and, say, the beneficiary, or in one case, maybe the grantor and the trustee, then you've got different powers through the parties, whichever way you want to play it. But the key is, whoever's the signer on the instrument, that was the grantor of the whole thing. That's where it all began. But if you didn't express it to be a trust from the beginning, Here it was a trust because there is no money and everything has to be a trust. When you go to the grocery store to buy groceries, you think you're paying for something with Federal Reserve notes, and that's just your purchase. You aren't purchasing anything. You're forming a trust. Same way at the gas station when you buy gasoline for your car. You're not buying gas, you're forming a trust. Everything today has to be a trust. And we are forming hundreds of trusts today, probably in some cases. But are we treating them as trusts? Did we realize they were trusts? I don't think so. But now if they give me an offer that comes in the mail, say an electric bill, I'm going to treat it as a trust. It's an offer for a debtor-creditor relationship only if you don't know that it's a trust. So I'm going to express it being as trust by forming the four elements necessary. I'm going to have intent, purpose, parties, and specific res. I'm going to turn that offer into the specific res, and I'm going to return it to them as the special deposit under trust. And if you look under Black's 4th edition revised, it says under the definition of trust deposit, a trust deposit is for the purpose of the depositor to make a payment for an obligation or a debt or some other purpose. So whatever the grantor really wants to do, he really can do, as long as it's for a lawful means. And I can use that deposit to pay a debt or an obligation. I could give the specific orders to do conversion and convert the assets to, say, money, whatever their money is, and take care of the debt. So the remedy is really not in debtor-creditor, it's really under trust. We're really moving titles in trust functioning as commerce. So bond is my word, and a word is really my bond, and really we're talking about a trust, a pledge, a duty, an obligation for a party called the trustee to do whatever the will or the purpose or the intent was of the grantor for the benefit of another party. The third party could be a third party or could even be the beneficiary, could also be the grantor himself. So what I liken to debtor-creditor under the except for value is really the Gilbert Law Summary's book on trust on page 127, whereas under section A there, starting at section 441, it's talking about the lienability of beneficiaries' interests. And we would also want to see section 98 on page 27 for a tie-in. But it says on number 1, the right to transfer in general in section 441. Beneficial interest in a trust are frequently lienable. In other words, that's a lien by the beneficiaries unless there is a valid provision to the contrary in the trust instrument. So thus, a beneficiary can assign, pledge, or encumber her interest or even transfer it in trust for another. And also, if the interest is not conditioned on the beneficiary's survival, it will pass by will or by intestate succession. And under A, the rationale, the beneficiaries are equitable owners. Beneficiaries are equitable owners of the trust estate, and their interests, in other words, their title, are property, and each therefore has power to transfer that property and convey her interest in the trust to the same extent that she could transfer her other property. And B, transferee's rights under section 442, and here's where it comes in your except for value and return for value, although this is not except for value, return for value. This is likened to it under the debtor-creditor, but this is trust. B, transferee's right under trust. This is the same effect as that. A beneficiary can assign only such interest in the trust as she has. The transfer is not a transfer of the trust res itself, but only of an equitable interest. That would be the beneficial title therein. And whatever conditions or limitations, that would be the lien that attached to the beneficiary's interest prior to the assignment, apply against the assignee. So that becomes the hot potato. And whoever I give it to or whoever I assign it to now has the hot potato. And that would be the person I would return it to. So once it's attached to beneficiary's interest, I flip the hot potato to the new assignee, and that hot potato transfers with it. There's your return for value. So that's how we would treat something similar under trust, but it's likened to debtor-creditor. It comes into being able to make the claim that there is a trust. Because what if the judge says, I don't see a trust here? Well, you have to prove a trust. That was the Mack truck door opening for you to drive that truck through when the judge said that. And because that's an opportunity to prove the case, that there is a trust. And how am I going to prove that there is a trust? Well, intent and purpose, 1 and 2, that's by the grantor. That's pretty simple. And parties is also simple because there's only 3 parties to the trust. That's grantor, trustee, and beneficiary. So all I have to do is, since I'm the grantor making this out, signing the, empowering everything, granting everything by my signature, all I have to do is define who the beneficiary is and define, say, who the trustee is. And then the specific res, number 4, would be the actual offer itself or the case itself, what I would turn into the trust res by claiming it using the moving titles platform. But if it wasn't a title, I would have to create a title first, claim that title, then move that and merge the titles if necessary, if that's what I wanted to do, was terminate the case. Or I could take and come in and compel the trustee to do the duty for the disbursement if he didn't do it. So there's 2 options there I have to do. So the third step then really is to collect on the disbursement after I expressed and proved the trust in step 1. Step 2 would be claiming and creating, claiming, and merging the titles. And 3, then to collect them on the disbursement. Whichever way I do in number 2, I'm still going to end up with the same thing in number 3, collection on the disbursement. So I've got the specific trust res, this property. I'm putting it into special deposit. And once I put it into special deposits for the purpose of whatever I wanted to put it and use it for. Beneficiary. But if I am the beneficiary and the grantor, and the trustee has to do the duty to, say, pay the obligation, which is nothing more than the same thing on the scenario of a mortgage, because everything is really operating the same way. And once we get the model down, we can put the model and apply it to anything at all, any kind of offer that comes into the mail, whether it be an indictment, a charge, or a bill, or whatever you want to call it. So proving that trust, I'm going to have to be able to create records that are evidence that will be not objected to in court. So I have to know a little bit about evidence rules. And one of the things we use is a notary, because a notary's record is self-authenticating and is outside the hearsay objection to the hearsay rule. So that's why we use a notary on everything. A notary's going to certify it, and that notary record actually becomes the evidence that I need to prove the trust, because a trust forms upon the present transfer of trust property. So whatever the trust property is, the specific trust res, when I form a record of a transfer, which is one of the methods, transfer is one of the methods of formation of trust, and when I have 2 records to substantiate a transfer, then I've created a trust. So there's 4 methods of formation of the trust. One is declaration by words or conduct. And 2, there's transfer, which I've talked about, which is really under, say, UCC 3-200s also, which is negotiation, Article 3 there. And A is endorsement, which is a signature. Anytime somebody signs, that's an endorsement. And B, a delivery. And C, an assignment. An assignment we're going to do on the UCC 3 after we claim it on a UCC 1. And D would be by operation of law. So that's under number 2. So let's go back. Number 1 is declaration by words of conduct. Number 2 is transfer, and then there's 4 subs under that, 2A through 2D. And number 3 is by appointment, and number 4 is by contract, which is really going to be formed in the future of the trust. But the ones we're going to use the most of is going to be that number 2, the transfer, which is really going to be an endorsement and a delivery, because I'm going to prove an endorsement on a green card sent by certified mail or registered mail, because when they get their green card, they're going to sign. And the signature is, like I said, an endorsement. And it's going to prove also delivery, which is one of the methods under transfer. So here we have a method of transfer, representing transfer, or method of formation of trust being endorsement. We have delivery, and then C is assignment on UCC 3. So when I do a UCC 3, after I've claimed it on U1, that it's mine, I can do something with, I'm going to sign it to somebody, and I'm going to assign it to, say, the trustee, whoever that may be. The trustee is going to be a present transfer proved by the endorsement and the delivery, the green card, of a specific title representing the trust res. And at that moment, the trust is formed. And I'm going to have a notary certify it, that it was done on a presentment, the endorsement, the delivery, the green card. And I'm going to have also an assignment under a UCC 3 and certified copies of that pulled out. And I'm also going to put a notice into the county of a filing, pull that out certified. Now I've got multiple records to prove that I transferred trust property, and that's the main thing, to prove by record that you transferred specific property to the trustee, and that's when the trust forms. Now I got a trust, and I can prove I got a trust. So when I made a claim there was a trust, and I came in and I proved the trust, if this is in a court case, I'm going to come in and do it specifically in one place, because everything I'm doing administratively. It's all private, and if I bring that into court, in the public side of the court, I'm going to waive it, I'm going to bring it back in, and they can't stand that information. And the first shot across the bow is that you're bringing some in, is they're going to say, hey, you need to go for a psych evaluation. So that was the warning shot that you're going the wrong way. And if you didn't take heed, you're going to lose all your substantive rights, because you're putting it in the wrong place. It needs to go in chambers. In order to get into chambers, you're going to have to put a protective order on it, because the protective order proves that it is CCI, which is confidential commercial information, along with also known as trade secret information. And all this comes under your discovery rules, and in particular in Florida here, it's 1.280, and that's the general rules for discovery. And under C, that's the protective order, and specifically C7, which talks about CCI and trade secret information. So the protective order establishes the fact that you have trade secret information that can't be revealed into the public, because really it's state secret, and you need to look that up in Black's Law. State secret information, which is your trade secret, which is your CCI. It can't be brought into the public. Black's Law 8th edition, state secret. It says a governmental matter that would be a threat to the national defense, or, here it comes, diplomatic interest of the United States if revealed. So you are foreign to the United States jurisdiction. They are foreign to you. So everything that you do in an intercourse with them is considered to be diplomatic relations. Continuing on to Black's Law. Information possessed by the government and of a military, or again, here it comes, diplomatic nature, the disclosure of which be contrary to public interest. That's the whole thing. It's contrary to public interest, because they don't want the public to know about this stuff, that they can do it. It's state secret information. State secrets are privileged from disclosure by a witness in an ordinary judicial proceeding. You can't bring this stuff in on the public side of the court. That's why they shoot the gun at you and say, hey, you got to go for a psych evaluation, the warning. We got to bring it into chambers. So once we have a protective order established on it, now it's established to be trade secret information, confidential commercial information, and that gives you the reason for the in-camera hearing. Now, if they don't grant you the in-camera hearing, they're not allowing you to bring your evidence in to prove your case. What's that in violation of? That's in violation of due process. Now, do you mean to tell me we don't have any due process in this country left? I believe that we have at least some kind of substantive rights left that we're functioning in the public. We don't have a total dictatorship, do we? Well, if they denied me due process on an appeal, that's an automatic win. So that's how we get information into the court. And that information we put into the court was the proving and the claiming of the trust. And once I get in there, then I can give the instructions to do the set-off and the discharges and bring the accounts to closure and settlement. But it's the rule of the signatures. It all starts there for the formation of the trust, or the formation of the relationship of a trust. And that's where we need to be gearing our minds into, where was the signature put on the first time? And a lot of people are having trouble with that, too, because they're not coming back down to where the signature on their particular case started. That's where the trust was formed. But if you didn't express it at that time, and even if it was 5 years down the road or 10 years down the road, you could still go back and re-express it and change it around to trust. So all these sub-trusts that we're creating are really trying to gain access to the SETI Key Trust, which is the Social Security strawman account. So when we fall into a dishonor under a case under debtor-creditor relationship, they have the ability to access the account for the funds that are floating with the face value of the bill or the complaint along with all the bonds that are attached on the background, the bid bond, the performance bond, and the payment bond, which is really what they're after, because those are the big ticket figures, and that's what's really paying all the fictions, because the case value itself probably doesn't pay the electric bill on the courthouse. But the bonds in the background is what they're after. So when I claim the trust as being at the case, the trust res, and all proceeds therefrom, therefore in one fell swoop, everything is generated and tied to that case are mine. And they go into special deposit also, and they cannot be touched by them, because I didn't authorize it. But I can't tell this stuff in open court on the public side. It must be explained in the paperwork in chambers, because it's state secret, it's confidential commercial information that is going to be a shock to the public. They don't operate like that in the public. Yeah, we have chaos then, which brings back to that old TV show, Get Smart. Take control, because we're all fighting chaos. Key was in getting smart. So the alienability of the beneficiary's interest was a key thing. It also says here on page, let's see, section 98 on page 27. 98 on page 27. 98 on alienability is because trusts are created only by some form of transfer by the settlor, even if the form of declaration passing title from the settlor individually to the settlor in their fiduciary capacity. It is usually, if somewhat casually, stated as a standard doctrine that the interest held in trust must be alienable or transferable. And that's the restatement of the second, section 79. Now they go into the common law, section 99. At early common law, certain future interests, example possibilities of reverter and contingent remainders, were non-alienable and therefore could not be transferred into a trust, although the example here, the retention of a reversionary interest in the trust estate after transfer of the trustee of a fee simple determinable or other interest in trust property that is less than that held in trust was permissible. Today, however, in most states, all future interests are freely alienable and may be placed in trust. Where this is not so, the old disability remains. So what are they doing? They're construing the trust, because we never expressed the trust in 1776, the Declaration of Independence, which basically says that we have all rights given to us by God, and all those rights are unalienable, can't be transferred. But you see, everything about today is about commerce and moving titles so that they can tax the movement of the titles. It's all about commerce, and commerce can't do with this kind of a narrow view. So they have to make the titles transferable or alienable. Transferable is the same as a lien. So B, it says here in section 100, inalienable property. Certain other types of property are not alienable and hence cannot be transferred into a trust. Example, certain tort causes of action in some states or an interest of the beneficiary of a spendthrift trust. And your Declaration of Independence is nothing more than a spendthrift trust. So it says, but note, under 1, strictly speaking, the standard doctrine referred to above applies to transfers into trust and not to whether inalienable property can be held as a trust res, and thus if an inalienable cause of action arose in the trust, it would be held as a trust asset. And it goes on in section 101 talking about the identified or identifiable trust res. But since we're on talking about the spendthrift trust, let's go to section 460. Section 460, which is on page 131 of Gilbert's, section 460, and this comes under B, the restraints on alienation. So it says the spendthrift trust is one in which by statute, or more often by virtue of the terms of the trust, and remember the terms of the trust is the Declaration of Independence, continuing on, the beneficiary is unable voluntarily or involuntarily to transfer his interest in the trust. In other words, he cannot sell or give away his right to future income or capital, and his creditors are unable to collect or attach such rights. And this type of trust, the Declaration of Independence, in other words, is usually created to provide an interest for the beneficiary that will be secure against his own improvidence. In other words, his own mistakes. So even if you made a mistake and got into trouble, you still couldn't transfer your rights under the Declaration of Independence. And that's the estoppel. That stops everybody from transferring coming at you. But is that what's happening today? Aren't they leaning up your property? Well, then that must not be so. The Declaration of Independence must not be in effect then. So now we go to section 498 on page 139. So I don't know exactly when this came about, but say sometime after 1861, the Civil War, sometime between there and 1933, a protective trust came about. And the protective trust, it says under 498, is as long as been used in England, a protective trust, in other words, been used in England and is increasingly used in American jurisdictions. A protective trust usually is an ordinary trust that pays out its income regularly, but which upon an attempted voluntary or involuntary alienation of the beneficiary's interest becomes a discretionary trust now. So anytime somebody tries to take the beneficiary's assets, attempts to voluntarily put a lien against it, and tries to collect on the beneficiary's assets, a protective trust is now being construed, because they are saying under the modern view that we don't have unalienable rights any longer under the Declaration of Independence. We have commerce coming in and reconstruing things to mean for the benefit of transferability for due commerce, because now the creditors are saying you owe and we want to collect. But a discretionary trust was formed after this protective trust due to this attempted voluntary or involuntary alienation of the beneficiary's interest. So now we jump to section back a page, on page 138, talking about the discretionary trust, section 490. The discretionary trust is one in which the trustee, now that would be the U.S. bankruptcy trustee, is given discretion to make or apply or withhold distributions of income or principal, or both, or for one or more beneficiaries, whether or not the instrument provides standards for the trustee's guidance. Now, whether or not the instrument, that be the Declaration of Independence, provides standards for the trustee's guidance. So they're allowed to withhold. So that explains why all along we are not any successful at getting a remedy under whatever method you use, because it's per the discretion of the trustee, because he has the discretion to decide whether or not to do the set-off or the discharge solely for his own discretion, because he's looking at it and saying, well, if I disperse the funds to the beneficiary, as soon as I do, the creditors are going to jump all over his assets and going to take his assets. I can't do that, because that would be in violation of the trust. All these assets were put into trust in, say, 1933 to protect them from the creditors. Creditors were trying to seize the assets. So about 1933, that's when the discretionary trust came in. And they voluntarily gave all the assets into this discretionary trust for protection, because they really weren't enforcing the Declaration of Independence, where all titles, rights, and interests were held in trust, were unalienable. It was designed to keep the beneficiaries from their own impoverance. So now what is happening since then is by prescription. And prescription is an act establishing through a authoritative rule and the effect of elapsed time in creating and destroying rights, the extinguishment of a title or a right by failure to claim or exercise it over a long period of time. So now nobody has claimed the trust, so there's been a failure to claim the trust, and they failed to exercise it, and they're going to destroy and extinguish your right and your title to do that. They're going to extinguish your right and your title to do that. Isn't that basically kind of what they might have done already, somewhat similar? They come up with this Patriot Act, and they say, well, you know, there's no more habeas corpus. We throw you in jail because we don't like the way you look. We can even torture you. So what do we do? What do we do? Well, I'll tell you. If we look up in Black's Law, that was the definition of prescription. They're going to do the extinguishment of the right by prescription. So you're being prescribed by prescription. Now, if we look up the definition on Black's 8th of, say, the definition of acknowledgement of debt, let's look that one up. And by the way, have you ever wondered why, if you ever did a debt validation, say like under 9-210A4 under UCC, asking for a statement of account for debt validation, have you ever wondered why they never respond to any of these? This will answer that also. Acknowledgement of debt, Black's Law 8th edition. Acknowledgement of debt says recognition by a debtor of the existence of a debt. Now here's the bingo. An acknowledgement of debt interrupts the running of prescription. Let me read it again. An acknowledgement of debt interrupts the running of prescription. So to put an estoppel on a prescription, just a simple acknowledgement of the debt puts a stop on it. Now I'm going to assume that it's going to be probably within 30 to 90 days before it would time out. But that's going to get you some time. In fact, you could even put in an acknowledgement of the debt and have it self-renewing for, say, a set amount of time until you could get the paperwork put together. So the reason why they do not ever do a debt validation, because if they acknowledge there was a debt, that would end the prescription. And the prescription is the foreclosure. Because now you're in agreement with them, and if you're in agreement, there's no controversy, no case, and they can't foreclose. Just a simple acknowledgement of the debt, which is an agreement with them, which ties right in with the scriptures. Agree with your adversary quickly, at least he take you to court and extract every cent that's due him. So when we put an acknowledgement of the debt and we follow that with or along with a settlement, an order for a settlement, that right there would be the estoppel and give us time to put in and prepare the paperwork for what is needed to do the settlement. And how we're going to do the settlement. I've gone through this before, but I'll do it again. So if we drew a circle, say in the middle of a paper, about a 6-inch circle, we drew a line right down, vertical line right down the center of it, split it in half. And on the left side is really the public side, the minus side, where the liability is. And on the right side is the asset side, or the private side. Now, I would draw a line, a horizontal line at the bottom of the circle, straight across. And now what you have is the traditional upside-down T account, which is nothing more than a ledger under accounting, where you have assets on the right and you have liabilities on the left. So all those people that are going into the DTC are going to be falling into a potential trap. So when they go into the DTC and they go in answering questions, they are not asking questions as king, because a king always asks questions. So it's ask king questions as king. So the one who asks the question is the king. And they're asking the questions whether or not you know what you're doing in there, and you're not going in as the king asking questions. They're asking the questions, and they're the king, and you're the debtor. And those people that are successful to get in there think they're going to be getting access to their accounts. And here's where the big benefit comes in. And if you fall into the trap by taking the benefit, you never even got out, and you got yourself in a bigger mess than what you got into, because you are just nothing more than a better paid slave. Because they're going to give to you all the treasury securities, the treasury bills, the T-bills, and maybe even the gold certificates or whatever's in that account. They're going to give it all to you. And at that moment, what you do with it is going to determine whether or not you're going to be succeeding in completing what you thought you were starting out doing, or whether you're going to never get out and you're going to increase the debt even farther, and they're going to love you for it. Because if you take those certificates, those T-bills, and you spend them like money, like they hope you will, you're going to take the benefit, which is the debt, and you're going to spend it back into the debt system and thinking that you've got access to your account, and you didn't. So all those debt titles on the left side, we're going to draw, inside that left side, we're going to draw another smaller circle, and we're going to put a capital T in there, and capital T stands for titles. And at the foot of that T, we're going to put a small d. The D stands for debt. So it's the titles to the debt on the left side. We're going to do another circle on the right side. We're going to put a capital T in there also. Now that's the titles. And at the foot of that T, we're going to put a little a. And the A stands for assets. So it's the titles to the assets. Now, if you take those titles to the debt on the debt side and you spend them, you're just going to create more debt, double debt, paying debt, and you can't pay debt with debt. It just keeps mounting up, and that's why they're loving you. And you're creating more problems than you realize. You're putting the final clinches on the whole collapse of this whole thing. But if you treat it as a trust, and you take the title and you draw a line from the TD up to, now we're going to draw another circle at the top. And we're going to put SM in there. That's the straw man account. We're going to take and merge the titles. We're going to move the title, the TD, and we're going to draw an arrow to that SM. And we're going to move that title to the debt into that SM, that straw man account. And on the right-hand side, the TA, the title to the assets, which is going to be the same amount as the TD on the left. They're going to be equal. We're going to move that title. We're going to draw a line up from that TA up into that SM straw man account. Now what we've done is we've settled the accounts. In effect, we're closing it. You've got the assets equaling the debts. And what happens when you take a minus and a plus and bring it together? Well, it discharges on the public side and it sets off on the private side. You bring the account to zero. But here's the thing. 1 penny of real money, lawful money on the private side will discharge all debts, all fiction money on the liability side. So if I fell into the trap and used those titles to the debt as money, I never did collapse the trust. I never did terminate the trust. Trust still exists. But if I move both titles to the debt into the straw man and the titles to the assets, the straw man account terminates. The trust purpose has been fulfilled. There is no trust. And what happens when the trust is terminated? The trustee must wind it up. He winds up the trust and he terminates the trust. In other words, he has to disperse the funds. The real money, still being held in private, minus, say, 1 penny. So now, what we're going to do from the remainder, let's back up a little bit. We're going to, after we gave the order for the settlement, we're going to give an order for the discharge on the public side. We're going to give an order for the set-off on the private side. And we're going to give an order to set up a new trust on the private side. And once that strawman account is closed, the remainder from that account is going to be transferred into the new trust. And that new trust you're going to get a whole total different kind of credentials for. The strawman account with his capital names, with all the accounts associated with him, are eliminated. They're gone. They're terminated. Period. All your electric bill accounts and everything in that way will no longer exist. But you're going to form a new trust, another account, and you're going to have the remainder of that assets being put into that. And that's going to remain on the private side. Then you're going to come back over and you're going to order a new trust to be set up on the public side, an LLC, say, for example. And you're going to order the Treasury to do the trade or whatever they're going to do to generate the interest held on the property or the assets held in private, and to deposit that interest and that LLC on the public side. And you will live forever on the interest that was generated from that. And as long as you just use that interest to purchase goods and service, that the goods and service that you purchase are consumed by the real man held in private, as long as you don't conduct a business with that account, that new LLC, you won't be commingling your funds again, and you won't be creating any new debt. So in effect, you've taken care of the war debt, taken care of all past debts, and you've paid all present, and you've paid all future debts that may be in the future. And you've discharged them on the public side and set them off on the private side. And the remainder was transferred into this new account on the private side, which was generating interest on a new LLC on the public side, and that interest is placed into that. And you will write checks like that, and nobody will be the wiser. And it is not taxable because it's foreign source. And you will be given the credentials to identify this new trust entity, and you'll become whoever. And you'll be able to travel like you were before, probably with more freedom than you had before under today's terms. So that's basically it in a nutshell. The documentation's simple. As long as we do due process and notify all parties, and they will never answer back, because they never have. Because if they did, they'd be acknowledging the debt themselves, and it would stop the prescription. So we have to go and ask questions, because the one asking questions as king is king. And the questions I want to be asking are, do you have all the necessary forms in your possession to close and settle this account? If they say yes, well then you've already got the order for the settlement, then close and settle it. If they say no, then I would give them an order to give me the forms that I need to complete the information so you can close and settle the accounts. It's as simple as that. I think we make things too hard under this debtor-creditor brainwashing that we continually go back to like a dog to its vomit. And we don't have to. So that also explains the reasons why some of these 1099 OIDs that were withholding, they put on the withholding there and taxed it back to the principal. And as soon as they got it back to the principal, the IRS seized the funds or locked up the account. Because the account, the IRS accountants couldn't give the disbursement to the beneficiaries who were debtors, because as soon as the assets were transferred to them, the creditors would jump all on them. So what they had to do is they had to seize the assets and apply it to the debt. And that's why you didn't get any funds. And until we pay the past war debts, all the past debts, present debts, and future debts that may be out there, do the discharge on the public side to set off on the private side, terminate that account. So with that, why don't we open it up for some questions? How about it? Anybody have any questions? I believe it's press *5 for an unmute there. So the fellow who was on the call right at the beginning there, you asked basically, you know, to answer your question.
Yes, Christian did. This is Bill North. Can I get a copy of this session? Is there a way to do that?
Yeah, what I'm doing is I'm putting a link on my website that'll get you to the downloads of all the recordings that are available, but I don't quite have it up there yet, so if you will keep checking on my website, movingtitles.com, and you can't do a Google for that because it's too new. It doesn't show up in a Google search. You have to punch in directly into your browser, movingtitles.com, and enter that in, and it'll take you directly to the site.
Yes, thank you. I've been there a couple of times, yes. Thank you.
Yeah.
This is very clear, and I'm glad you pointed me in the right direction. I was going the wrong way.
Yeah, I think that, you know, with this explanation based on trust, you know, it makes things a whole lot clearer. It would have been
I guess trap. Where I got confused was with you using the UCC. Now, you said that's a debtor-creditor instrument, but we're still using UCC1 and UCC3.
Yes. If you'll notice on that UCC, on those forms, it says on one of those little blocks down, I think it's number 5, I believe, it says non-UCC filing. So if I check this little block, it is no longer a UCC filing.
Wow. And then once again, on the UCC1 and UCC3, we keep on the private side, and we acknowledge it by using the registered mail identification number.
Right, right. So what I'm doing is everything I'm using, I'm specifying that it's non-negotiable. As being non-negotiable, that's strictly private.
Exactly, right.
Anytime I've got a negotiable instrument, what I've done is I just put myself back under debtor-creditor. And that's all we've been doing. All these bonds and these set-off bonds and discharge bonds and things, all we've been doing was just operating on under debtor-creditor, money orders, promissory notes, all that stuff. We were just creating bigger debt.
So basically, what I got of this was, if I receive a bill, I can be the grantor and just transfer that to a trust, to a particular name of trustee for my benefit. Is that what you're saying?
Yes, right. Under a special deposit, which is also known as a trust deposit.
Okay, cool. How does that work, the trust deposit?
Well, trust deposit, if you look up in Black's Law 5th Revised, it says the trust deposit is where money or property is deposited to be kept intact and not commingled with other funds or property of a bank, and is to be returned in kind to the depositor, or devoted to a particular purpose, or requirement of the depositor, or, here's the big one, payment of a particular debt or obligations of the depositor, also called special deposit.
So it's just a matter of specifying the purpose for the deposit of the raise.
Yes, and I believe under the restatement of the seconds, the law on the trust, I believe it's section, without me checking, 345, where it talks about conversion. I can convert trust property into, say, cash or credit, and then order to be applied to the debt, or the obligation, or the purpose of the grantor.
And then the trustee has to do that? Is that what you're saying?
Yes, or else he's in breach of trust.
Wow. And now it has to be, now in that case, it has to be a non-negotiable, or?
Yeah, because it's non-negotiable. It's held in special deposit or trust deposit. That's non-negotiable.
Okay, got it. Cool. Yes, it makes a lot of sense.
Okay, another question? Anybody else?
Thank you.
Star 5.
Star 6, Christian.
Is it star 6?
We find that many educators are quite proficient at teaching us their knowledge, but that many don't apply it.
Right.
Some people can think of a few examples. Now, I know this is, shall we say, pretty new to you, although you have spent a great deal of time obviously studying it. And as someone said last week, you were hot. I'll echo that sentiment this week. Very clear, very concise, beginning to end. I got a little confused there as we moved into the DTC, but nonetheless, you did an incredible job at putting your knowledge forth concise today. But my question to you would be, have you indeed begun to apply this the fashion you have, whether it be for court, bills, other people's debts, or have you not yet? And if so, why not?
Yes, we have put it in effect in a limited way. We had one foreclosure that was on a sale block going to be foreclosed, and 2 hours before, we put in some material and went up to the judge to ask him, to get the thing pulled off. And we thought we were unsuccessful at the time, but the sale was discontinued. But that time, we just put in an NOI in the expression of the trust. We didn't follow it with the proof of the trust, which is the SOI. So we took another case and we tried the same thing as we did in the first one, and we went the second step a little more. We put the SOIs in fact there, and that case got closed down. So that's when
so you didn't even have to go in camera then. You were just able to deal with it right.
We didn't get in the camera yet. No, we didn't get in the camera with proven.
Right in the courtroom. You came in with that, and you basically blew them out of the water without even needing to go private.
Right.
Wow. Okay, so just 2 foreclosure cases, to your knowledge, so far.
So far, yeah. And we've got some others that are trying different things. I know they're doing it on themselves, based on what we've been talking about. But, I'm not totally aware of what they're doing and some of the successes on that yet. But like I said, this technology is totally new. This is getting into the ground floor, and we're just now starting to create a wave and riding the wave.
Right. Well, you've, I think probably some great number of months you've been on these phone calls. I've only been with you 4 or 5 times over the past 6 weeks, but I think you've done this for 8 or 10 months, haven't you?
No, I've had the Money, Banking, and Trust show for almost going on 2 years now.
Okay, and the NTT just came in November. So
yeah.
You're really pressed in your knowledge.
Yeah, well, I've been studying trust since I started the show, but, I didn't put a label on it and coin the phrases and make it public, so to speak, because at that point I saw the direction to go. And I said, there's no way of waiting, let's go.
Well, again, tonight, I'll say you laid a solid claim to it. The way you put that forth tonight, beginning to end, with such great clarity. Normally, I sit here and take notes and go through the book. Tonight, I chose to lay in the dark and listen, and I'm glad I did because I was able to just wrap my head around it all so much more. I'll certainly listen to this again. I appreciate your time, previous and present. Thank you very much.
Right. I'd like to point out to everybody, it doesn't really rest on the fact that we haven't done any of this, whether it's me or anybody else. It's whether or not you've studied the facts or the doctrine, so to speak. And this is not theory, because this is actually ripping off and exposing how they are operating presently and how they've operated in the past, because it's explaining how they've been doing things. This is not theory. And I'd like to point out the fact that just because me or anybody else really hasn't had any experience at it, don't allow that to stop you, because if that's the kind of attitude or mentality that we have, then Edison would have never discovered the light bulb, or Christopher Columbus would have never discovered America, because they would have said, hey, unless you've done it before, then you can't be doing it. So unless you sailed out there and discovered America, you can't go out and discover America. Or just because we didn't discover the light bulb, we can't discover the light bulb. So that kind of thinking is not quite right. It depends upon whether or not you believe on what we're talking about. That makes it willing for you to step out by the belief or the faith based on sound judgment, based on facts. Not just on conjecture, but based on facts, material facts to support, to do what you think you honestly believe in. And I can see trust from studying trust that it makes a whole lot more sense coming at it from the point of view of trust than under the debtor-creditor stuff that we've done in the past. And really the trust thing puts an explanation on some of the things why we haven't been successful. And I really think that once we get this down and understanding the basics and its application and mimicking what they've already been doing and what they are presently doing, then we will have a greater success. And in fact, I would say we should be able to get up there to 100%. In fact, I can see where we don't even have to go into court. The only way I'm going to go into court is if they drag me in there. Because really I'm going to call a Treasury Directive hearing under the IRS Treasury Directive 25-06 and under that USAM, U.S. Attorney's Manual 6-4.010. Now that basically says that that individual master file in the IRS is all other agencies got to comport to that. And who sets up the information in that master file? We do. You and I do. We self-assess ourselves and we sign the declaration forming a trust on a 1040 form that appoints our status as being trustee on that trust. We did that. And when that judge looks at that folder and sees that in there, and we come in as beneficiaries, say, then there's a conflict there. And we got to go back in and correct that master file to the way that we want it, the way we understand it. And that would be in conflict with that Social Security account if we're listed as beneficiary on that one account, and our master file lists us as trustee on that one. If all the agencies, including Social Security, must match up with that one, then we must be incompetent. So we need to go back and get the record straight. Claim that trust in the IMF, and from that point you have standing to come in and move the titles and terminate the trust. And when you terminate the trust, you get the disbursement. And the paperwork's not that hard. I think trust is a whole lot simpler. And I don't need to dance on their tune to their stage using their tools and expect to get any better results than what they're going to give me. So any other questions?
Yeah, Christian, this is Eric.
Hey, Eric.
Florida, how you doing?
Good. You?
Oh, great. Well, I've been listening to you a lot and doing lots of research to come up with some more questions. One of the things you said recently is to use non-precatory language, and non-precatory language is order, command, and
direct.
What was the other one?
Direct.
And direct.
Yep.
And you were talking recently about when we send out a notice in demand, for example, for the genuine winning signature promissory note, should we be sending out a notice in command, for example?
Yeah, or direct. I hear about order you, direct you to, so you got to have the wording command. I don't really like command. I like order and direct. Sounds a little bit less,
okay.
But it's not precatory.
Could demand be considered precatory?
Demand? No, I don't think so.
Okay. So demand.
I would keep it more towards the command, direct, and order.
Okay. And last night, is it okay if I talk on this call about anything that you guys were doing on last night's call?
Yeah, go ahead. Sure.
Well, it's really a pretty basic question, and it's about the treatise on trust that you're currently studying. And is the reason that you're focusing on that so much is because it was pre-1933, and is that because it was pre where we came into this whole situation that we're in, and that's really the and I haven't read it yet, so I don't know. But is that book written for those of us who want to operate in the private?
Yeah, because Gilbert's Law Summaries is the statutory black trust, and the treatise on the law and trust by Lewin is the white trust, the private trust. It's 1776. It's before the statutes and codes. It's before the United States formation. And it's not under common law. It's under equity. Equity is not common law.
Now, you brought up the term equity, and I think there's a lot of confusion for some folks out there, because since I've been listening to you, you've clearly emphasized that the in-camera in chambers is the equity area, the man, the fair, conscious venue that we want to be in.
Right.
But then, even when we're standing in the public open courtroom, there is a equity component to that as well that's been merged with the admiralty.
Right.
And so if you could kind of help us understand the differences of those two equities that we're dealing with here, that would be great.
The pre-1933 equity that we're talking about is solely gained in chambers. But post-1933 equity, which has really been morphed into nothing more than statutes and codes because they've redefined it, that's in the public, on the public side of the court. So they've hidden the real equity in chambers, and they've given you something that's supposed to be equity, but it's nothing more than statutes and codes, and statutes and codes is the bond of obligation, a statutory trust.
And that's what makes these people that are utilizing the Tim Turner stuff so scared to get in the equity court, because it's really just a bond of obligation.
Right, right.
Okay. And
but if I want to talk about 1776 equity, my Declaration of Independence, where I have unalienable rights of the substantive man, that's in chambers, in private.
And when we're in that public courtroom, I've been there before on an event, and they really talk like you're not even in the room. And is that because there is no conscience there, because it's really just a move forward for the corporate to gain their profit? Is that really their agenda and nothing more?
On that side.
Say that again?
It's all form, process, and procedure on that side. And the real man can't show up because he's not the fiction. And it seems like the only thing that they realize that is not incompetent is one of their attorneys.
And once we get into the in chambers, okay, because your technology is so cutting edge and so new, and seemingly so grounded in so much doctrine and history, and now conviction.
Doctrine and history. I'm just revealing how they've been doing it all the way up to present. It's not so much doctrine; it's that I'm actually showing the practical application of it, and that's not doctrine.
Okay. Forgive me for using the wrong term. And also within the conviction of the are listening to you. One of the challenges we might face, though, is even once the people that are studying and live diligently and following you diligently to be able to be effective for remedy. If we were to share this with someone else to try and find remedy, would it be possible for us to go into chambers and speak on their behalf?
Well, quite possibly it might be, but I don't know about that. I'd run through some research on that. You might be able to come in as the friend of the court, say, or some of those other terminologies. Pre, say, Civil War. Back then you could defend yourself. You didn't have so many attorneys. You could come in yourself. So yeah, if that is being held in chambers, then it stands to reason that you should be able to come in there with, say, do it for somebody else in chambers. But I think we've got enough things to worry about as it is, without complicating with a few other more twists. Some would, get it down to its bare essentials, so we can get a finer grasp of what's going on and how to handle it. Elimination of possible variables. Keep it down to the simplest.
And you've spoken many times about perfect title, and the perfect title would be the circle without the line through the middle of it, which also would be a lloydial title.
Right.
Now, once we finally do achieve the notification of all the agencies that you spoke about when you were speaking earlier, and there's proper notice all over the place, and the IMF file is finally where we want it to be. At that point, would it be possible for us to attain a lloydial title, for example, on real estate?
I believe so, yeah, it has to be. That's when America, the common law, the republic comes back for that, at least that individual, or as a group that does it, or all, depending if we all do it, or we pay it for the all, let's put it that way.
With that 1 penny of real money that you were talking about, for example.
Yeah, yeah.
Okay. And one of the things that I was reading about was about in the merger of titles, and how it says that the interests have to be exactly the same. One of the things that brought up, and if you don't mind, I'll read the text for the group if that's okay.
Yeah, go ahead.
Yeah, it's subsection 159. It says merger of title, where a sole trustee and sole beneficiary are one and the same person. The result is a merger of legal and equitable titles, defeating the trust and creating a fee simple in the person. Interest must be exactly the same for merger to occur. My two questions about this are, number one, who determines what those interests are, okay, by whose decision? And then how do we determine the nature of what the word exactly means in this context?
Well, as the king, he doesn't really sit down and know specifically everything that's being done, so he kind of gives the order, so to speak, as a general command to do what needs to be done, and then the grunts below them, the servants of government, have to comply and do the detail work. The person I would go that has to know the amount of the debt would be the IRS. They have to know the amount. Now, maybe they might not tell me the amount, and I really don't care what the amount is because I've got unlimited source of credit, say, and what the debt is, and just take an equal amount for the equal interest from the asset side and apply it to whatever the amount is on the liability side, so that they are equal in interest, so that the titles can be merged of equal value, say, or equal interest. And then send me a receipt. Send me a receipt that it's been settled, so that I know it's been settled. And then the remainder, put it in that new trust. And then I order you to generate the interest and put it in this new LLC on the public side that I can spend as I see fit on the consumables for the maintenance of the live man. Does that answer?
Now, once we have... Oh, keep going, I'm sorry.
Oh, go ahead. Does that answer it? Yeah.
All right. And then once we have that set up where we can actually have an account at a local bank where we can write checks from it, as you said, so no one would be to the wiser. Is there any, like if, for example, we wanted to pay a debt off for a friend, would there be any reason we wouldn't want to do that? Could we get into a situation?
I'd have to watch. I wasn't commingling funds now, although I could teach the other person how I did it. So I'd have to watch out about commingling funds because I don't want to be effectively connecting that new LLC with U.S. business or trade and find out that I've just ruined everything I've done and put myself back under a debt situation again. So it comes down into learning how to administer the trust once we take control of the trust.
That's probably going to be one of the trickiest things to learn over the long term, huh?
Yeah, well, I think it's really basically simple because as long as I stick with I'm purchasing goods and service for consumption by the real man, if that's all I'm doing is being a consumer and I'm spending it with the interest that was generated, then I've got no worry because I'm not commingling funds. As soon as I want to put that someplace else and go into somebody else's, commingle with the debt side again, like trying to solve somebody else's problem with my interest, then I think I'm going to commingle, and I better watch out and start thinking about what I'm doing. Now, there could be a workaround from that. I might form a separate corporation or separate trust, totally different, and then whatever profits it would generate, it would be taxable. But that would be a whole different ballgame. So
as long as we don't get into a situation where we're commingling directly with that LLC that you just mentioned, then we wouldn't have a responsibility to file any tax returns, right? Right,
because it's foreign source. It's drawn against the private side that's held in that new trust account in the private. It's a foreign entity.
And if we wanted
non-resident alien.
Okay, but then if we wanted to, for example, pay somebody's rent or their mortgage payment or whatever, then it would be possibly a good idea to set up an additional entity. So it would be a domestic organization that would that could commingle, that would handle some of those issues.
Correct, and that might want to be a private charitable trust, and I would fund that maybe with some of the interest that I've got. But that's going to function as a separate entity, and it's responsible for its own taxes.
All right, there's the bridge that we probably all are looking for, because there's a lot of hurting people out there that we'd love to help.
Yeah, well, I think we're going to help them the best by getting them educated so that they know and understand that it's all about a trust. And then they can go do this process. And they can claim their own trust, because everybody's got a trust. Everybody has a strawman trust that has a birth certificate.
I know, but not a lot of people want to take their head out of it saying, you know what I'm talking about.
Well, am I going to jeopardize my standing and my position, to help somebody who doesn't want to know or understand? Then I think they're better off being a slave.
I can't. Okay. and the term state secret we've been talking about, where we can't disclose that in open court, is there any other situation where we might find ourselves needing to maintain that CCI, that private information, beside when we go to court?
Anything in the private nature, can't be commingled with the public, because you're commingling the terms, you're commingling the knowledge, and you're commingling, and you're in breach of the trust when you do that, and that's why you're incompetent. It's intellectual property can be trust res. It can be intangible goods. Intangible property can be, intellectual property. Could be res.
Okay.
But anytime I commingle with the public, then I'm in breach of trust. And if I'm in breach of trust, then I'm a debtor, because the trustee breached. And then that article we've been reading, right on the first page of that treatise on law and trust, it says that the trustee is the debtor. So if I get in a debtor position, I breach the trust.
You're talking about when you're interfacing with a public entity such as a court.
Yes, either with knowledge or understanding, or with anything that's trust res at all, interest or whatever.
And outside of, for example, a court, we would be functioning in our private capacity on an ongoing basis anyway, so that wouldn't be an issue outside of a public type of venue, correct?
Yeah, well, yeah, but am I talking to one of the straw man entities, so to speak, and or am I talking to the private man outside someplace? I don't know. It's kind of one of those touchy lines, fine line of what's public and private.
I'm trying to source out how to keep it secret and when it's appropriate to keep it secret.
Private contract, put it in special deposit, treat it as a trust. Remember what I said about every time you approach somebody, think about the relationship you're forming. Are you forming a debtor-creditor relationship, or are you going to form a trust? I can form a trust on intellectual property, just general conversation of knowledge, giving it to you. Right now we're forming a trust?
We are.
I'm trusting what I'm giving to you, you're going to hold in the private. And if you don't, you're going to commingle, and you're going to be in breach of my trust.
And isn't the potential fee $100 million?
Under a commercial venue, yes.
I think that's what you put out there. So, yeah, I understand. One of the things in the methods of trust creation that I'm trying to wrap my head around to see if it's even possible is one of the methods is contract. And because there's no lawful money, can we even enter into a trust by contract, because there's no lawful money, there's only legal tender? Right.
That's why I would say all contracts are really colorable contracts, which are just wrapping and hiding really a trust at its core. We can't have a trust, or we can't have a contract today. It's got to be a trust. So even if we think we're forming a contract, what we're really forming is a trust. And although we never expressed it to be a trust, that allows them to construe it, and they're going to construe it under the debtor-creditor, under UCC. That's how they're going to foreclose on you.
Okay, that makes perfect sense. Perfect sense. And let's see. Now, I have several people on the call with me that I brought into the call. I don't know if they have something they want to talk about, but I would have. I'll remain unmuted on *6 if anybody wants to come on the call and talk to Christian. For all the rest of you that are on there, because they all muted out, so the call would be clean.
Okay. Anybody else want to press *6 then? Anybody else? Got to be some other questions out there. Got to be full of questions. Don't be bashful. There are no dumb questions.
Yes, Christian, this is Bill from Newark.
Hey, Bill. How are you?
Good. We're just talking about the debtor, the trustee being a debtor, right?
Correct.
That's why if we're the trustee and we have to go to a court action.
But that's only once the beneficiary makes a claim. If he's a performing according to the indenture, he wouldn't be a debtor.
Oh, I see. Okay.
Now, if he didn't express trust, it could be under construment that that the indenture wasn't particularly worded, say. Just like the Declaration of Independence, there's no specific wording other than that we have all unalienable rights, but now they're construing that because nobody expressed it to be a trust. They're construing it the way they want to because nobody's saying anything. Nobody's standing up and saying, no, I claim that that is wrong. It's not that it's transferable. It says it's not transferable, period. And I think that's what the Founding Fathers had because they had enough of the England that was the tyranny and the constraints against them. And they designed that specifically in there for that purpose. They said, quote unquote, unalienable rights, non-transferable, period. But now let's operate on how they've construed this. Let's give them what they want. So I'm in agreement by acknowledging the debt, whatever they say I owe. Now the prescription's been stopped. There's an estoppel. I've been in agreement. Now there's no controversy. Now later on, then after everything is closed and settled, let's go back to 1776 and correct this and go back to that.
Okay, so then the beneficiary has to indicate, either the grantor or the beneficiary has to make a claim against the trustee, is that right?
Yeah, the grantor really can't make a claim unless he's reserved some kind of rights or he's co-beneficiary. Only the beneficiary can make a claim.
Okay, I see. So the beneficiary can say that I've been wronged by the trustee.
Correct, yeah.
And now, is there any threshold of proof for that, burden of proof?
Well, once you've made the claim that there is a trust and prove that there is a trust, all you have to do is make a prima facie case, and a prima facie case is nothing more than an affidavit put into court with a petition and claim that, hey, you breached the trust. The courts under equity will presume that the trustee is guilty because they're going to believe whatever the beneficiary says at that point.
Right, and then that ties into the issue of the commercial debtor and credit.
Don't construe it being back under debtor creditor or under trust. No, trust is different. Remember, the debtor creditor that I was reading from, the trustee as a debtor was out of that treatise on law and trust, which was 1888. That was before debtor creditor, UCC, and all that stuff that we had after 1933. We still had at that time lawful money.
Oh, I see. Okay. Right. That's where I got hung up on. Right. I got that. Well, thank you.
Anybody else have a question? *6. State your name, where you're from.
Tim out of Tucson.
Hey, go ahead.
I'm wondering, Christian, what do you think of the idea that obviously we want to do this with the SS5 and go for the K? What if one were to dabble their toes in the water a little bit by dealing with foreclosures or other bills and such in this fashion? Not being fully versed in this, but grabbing that little trust there, shall we say, and working this.
I think that your chance of success is going to be a higher rate than what we were, say, under debtor creditor or any other, say, methods. But you might not achieve the higher rate that we want to achieve by getting the whole ball of wax or cutting the head of the snake off altogether.
Okay.
You still got the root in the ground, and you still got these problems with the IRS. Got yourself as a debtor in there, and then if you try to come in and say as beneficiary in a court, you may have some problems because the records don't match.
I see. Okay. So a lot of groundwork to be laid first. Now, to shift a little bit, you've said before that if you had, shall we say, done something wrong here, that it would put you back into debtor-creditor. So if one grabs the whole ball of wax, to use your word you just did, and is it possible at that point in time to do something wrong that would put you back into debtor-creditor, and then what happens then? You got to go grab a new card and a new trust, and do you follow?
Yeah, well, let's say you commingled it after you got everything all straightened around. I don't know what would happen. You know, they may try to come back at you and take the whole thing back. I don't know.
And then, so, again, you've got 10 Social Security cards. Basically, jump in there, get another one, and start over again, maybe?
Yeah, you may have to redo the whole process again. Really, the process is not that hard. The whole process is really not that hard.
Yeah, I hear you say that. It seems big, but I'm getting a better handle on it, and thus the question.
Yeah.
You know, some are wondering, you know, is this the right avenue to be going down? And so is there a way that you could mess this up and cause yourself a big enough problem in the future that you wish you had not done this because you can't undo? And I just heard you say, no, I feel like you could just grab another SS5 and go get number, 3 or 4 or 5, whatever.
Well, now, this new trust wouldn't probably have a Social Security number.
Okay, so you've gotten your SS5 and done it by grantor, and you've got a couple with his trustee and beneficiary.
There be some other way that they have probably set up that identifies this new entity as not being in their United States jurisdiction.
Okay, so this maybe does cause such a problem that's, shall we say, almost irreversible.
Okay, but how are they going to charge me under their statutes and codes if I'm not under their statutes and codes?
Okay.
I think more comes back down to as functioning as pre 1888, say, or 1889, when the United States came in existence. We had common law, and you were only responsible, for certain things if you murdered somebody. I don't think you would get out of that because you're back under your brother's keeper. You're under the Ten Commandments. Your things are a whole lot simpler. And now you got the world being able to interface back into commerce again. Say in effect for getting the consumables that you need, all the fancy cell phones, telephones, and all this stuff, cars and things that you need. You don't need to dig in a hole, live in a hole the rest of your life because I got out. I need to have access to those things that I need. So that would be through that new LLC based on that interest that I would be just buying the consumables that I would consume.
Right. You had an analogy tonight about Edison. He didn't give up just because he messed up, kept going.
Yeah.
And
one more thing that didn't work to him.
Yeah, I was seeing this is very big. That, oh my goodness, I've got to grasp this whole thing and get it right, because if I mess it up, I'm in trouble. But tonight, you've sort of brought my mind around to something different, and the idea that I might maybe grab a foreclosure and work that in a court, as you've shown that can be done, or some bill that I've assigned over and done in this fashion, and learn this in that way before I go for the SS5 trust.
Right. You might not have the success rate maybe that you hope for, but yeah, I think it can be done that way.
But I'm learning. I'm figuring out this is not working and that's not working, and I'm learning this.
Right.
Where before I was saying I didn't want to do anything until I really grasped this.
Well, I think that you can't do any better than everybody else. At least that, I would say, would be probably the guarantee. I mean, whatever success rate everybody else is, I think you're going to have the same success rate, at least.
I see, yeah. With the debtor creditor, you mean?
No, with the trust.
You
don't claim the root and pull the root out,
I see. Okay. Thank you.
If anything, at least it's another tool to put in the toolbox. But if it is the sole thing that has been running this whole thing all along, and here it was disguised by debtor-creditor, because it wasn't expressed as a trust to begin with, and they've construed it to be debtor-creditor. So again, if it walks like a duck, talks like a duck, it's a duck. Do you see trusts? I do. Then how come the DTC, for example, which means Depository Trust Company, how come we're going in there under debtor-creditor? Why aren't we going there under trust? How come the IRS, which is Trust 62, how come we're doing debtor-creditor with the IRS? Why aren't we doing trust? It doesn't make sense. Why would we fight something that's trust coming in with some other kind of law form other than trust? And trust is equity, pre-1933 equity, or post in chambers. It makes better sense. The more I study it, I see more about trust that was, oh my gosh, there was all the time. And the other teachers in this have always said it's all about trust and bonds and insurance. But yet they don't go down the trust path. They go down the debtor-creditor rabbit hole. Well, I'm going down the trust rabbit hole, and anybody who wants to follow me is welcome. But I see it as trust, and trust is where I'm going to treat it, 100%. I've gotten away from the debtor-creditor. I've had successes under debtor-creditor, except for value discharge. I've done some of that stuff. I just wasn't satisfied at how it was turning out. There was no rhyme or reason, hit and miss, until I came across. I think that was just the success here and there that they give everybody. It was just a ring in the bull's nose, leading them down the path that they want them to keep them from the true path, which is 180 degrees back the other way, under trust. So anyway, another question? Press star 6, state your name, where you're from.
Christian, this is Tim at Tucson again.
Yeah, Tim, go ahead.
The Wuffett people I've mentioned them, the Wiley Health Fixed Investment Trust people, they were doing some calls, and they pulled in some fellas who had been working with trusts. One fella, at least 20, maybe one guy 30 years, setting up trusts for multimillionaires. They're a real big gig. Because of what these trust people were hearing, they came on board, and I think they're probably working together to create Wuffett team, as I've said before. I wonder if you've experienced that trusting, have you garnered the attention of people who have years of experience in working with trust? Have they come to you and given you an attaboy or told you you're onto something, or have you had fellows like that come your way?
No, not anybody's, that said that they knew everything about it and said, yeah, you're on the right path. I've had different people say that, though, but I don't know whether or not they're, operating in trust and that. I don't know, really.
Yeah, you're sort of in a different realm of the whole trust thing, I think.
Yeah, because I think most people are using it as a defense to protect assets from the creditor getting at the debtor's assets. And they're using a trust as a protective mechanism, and that's not exactly what I'm using trust for at all. I'm using trust as an offense.
Sure. Okay, that would make the difference then, I guess. Yeah, that sort of delays the question.
Nobody's ever done that before, as far as I know. At least I've never heard of it.
Loving it. Thank you, Christian.
Another question, anybody? Press *6. State your name, where you're from.
Yeah, Christian, this is Danny in Texas.
Hi. How you been?
All right. I've been quiet. I've just been sitting back listening and absorbing, and most of the guys are answering the questions that I have, so I just want to let you know I'm still on board.
Okay.
And I think the guy that was just speaking, he was referring to people that think they know a lot about statutory trust, and they probably do, but you're the only one that's been expressing the private trust. And I've been to quite a few different trust meetings and hearings and that sort of thing, but I'm realizing now it was all statutory, not private.
Right. Yeah, anything that's a statutory trust is really operating under debtor-creditor in the public. It's really the black trust, which is really this Gilbert's Law Summaries book. But I say that if I show you the black, then when you see white, you'll know the white when you see it by sight. And we're also studying the white under that the Trustee's Handbook on the Law and Trust by Lewin. And I tell you, there's some eye openers in that. Right in the first 2 pages. And then you tie that in with Law and Trust by Scott, Austin Wakeman Scott, and you got some case sites to support that right in that trustee's manual anyway. But you tie that in with Scott's on trust, and you got some dynamite stuff.
Yeah, I think I've missed how to access those 2 documents you're talking about there.
Well, the one by Lewin, the trustee on the Law and Trust, you could put that into the Google book search, and that will pop that up. That's a 2-volume, Volume 1 and Volume 2.
How are you spelling Lewin?
It's Lewin, Frederick A. Lewin. But here, if you just do a Google search, put this in quotes: A practical treatise on the law of trust. That's trust plural. If you put that in quotes and do a Google book search, that'll pop right up, and you'll get the first volume. And then to find the second volume, just put at the end of that, but not in the quotes. Put at the end, put VOLII. So that'll get you otherwise you'll be searching for a long time, because it took me a while to find the second volume. The second volume is only like a continuation of the first one, to like the first 200 pages, but the rest of the 800 pages is all case supports for the first volume. And then if you get the Scott's on Trust, Austin Wakeman Scott, The Law and Trust. It's a 1919 book. You could also get that on Google book search. Tie those 2 books together. Now that's the private trust. That's pre-statutory, pre-United States. Because this law treatise here, this Law and Trust, this is 1888, and this was based on. This is the first English, the first American version. It was based on the 8th English edition from England. So I've got some people doing some searching for we're going to go back into the English one version and go back to, say, like the 6th to get you back into, say, 1776 and see what that compares to this 1888 version. But here's the confusing thing. They use all these old terminologies like fee-offment, enoffment, fee-off-fee to uses, sedicati uses, and what the heck are these people talking about? We don't use that, but that was the trick that they're using to hypothecate and get us to pledge voluntarily our assets, because they no longer just change the definition of known words that we're using. They've taken the definitions and switched the words. And that made us go on a straight path, and they made a 90-degree turn and took a parallel path with us. So they made the switch. I always thought, well, they jumped off the track and formed a parallel path. No, they tricked us to keep on going. And so we're thinking, we're under this law form that we continued on in, and they actually made a switch by the definitions, putting the new words on it because they were going by the old 1888 version.
All by design.
Yeah. So just in the first 2 pages, there was a lot of revealing facts in there on some enlightening things.
Yeah, it sounds like a lot of dynamite there.
That book is actually the blueprint of how they've been operating all this time. So, any other questions?
Yeah, Christian, this is Eric again.
Hey, Eric, go ahead.
You mentioned something a minute ago about case sites. Now, when we're in the private, is there a need to utilize case sites since it's our law in camera?
Well, you ever wonder why maxims didn't work on the public side? Because maxims are inequity. So we'll use maxims. And one of the maxims is, he who claims trust must prove trust.
So do we need to utilize case sites in the private?
I don't think so, because under trust, I'm probably going to just use equity as, what is fair and just. And equity is a whole lot simpler. Equity is going to compel you to do what you should have done, or to compel you not to do, say, a breach of trust.
That really does make a lot of sense why everything gets a lot simpler, because then we don't have to do all that case research.
Right, yeah. The 900-pound gorilla is trust and equity. Equity is the 900-pound gorilla.
And Gilbert's being the statutory, so when we're in the public court, if we were to be in a statutory trust, there still isn't any conscience, even though there's the trust, and even if it's a statutory trust, there's still not a conscience where they're going to recognize you as the real man, because they can't, again, even though there's a statutory trust there, correct?
Right on, 100% right.
Okay. Are you going to put together a list of key points of study for the law on trust and the treatise on trust? Are you going to put together that?
Well, I think that law on trust, that treatise on trust, is so chock full of information, but yet you got to use the decoder ring. You got to have your Black's Law dictionary with you, the first version of the Black's Law, really, because that's the 1883 version, and that's going to get you with the 1888 book with the terms they were using at that time. So that decoder ring, you have that with you because it's very slow going. Because you almost got to look up almost every word, because even the words that you think you know, like in, or just a simple word like in has a totally different meaning. Because it said here, like, so the Lord who was in by his cheat, a deceiver, an abater, and an intruder, were not amenable to the subpoena for the first claim by trust, or title paramount to the creation of the use, and the last 3 were seized of the tortuous estate and held adversely to the fee to uses. But the word in by his cheat, the Lord was in by his cheat. In means under or based on the law of, and that is to bring an action in contract. And at that time we had valid contracts because we had lawful money. So he was in by contract, and an action on a contract by his cheat. So you got to be careful. The words that you presume that you understand, you almost got to look up the little words and see how they were defined back then to make sense of what they're talking about there.
Boy, they shouldn't teach us that back there in first grade.
No, they didn't. No, and they probably didn't want you to even go near there.
Now that
because all it is today is fee, fi, fo, fum, which is feudal times, and that's what we're operating today in.
And the treatise on trust and the law on trust, as chock full of information as both of those are, is that and the gentleman that wrote the Declaration of Independence, is that the frame that they're operating from, and that's why it's such a great document to utilize, because it is it's really from that whole frame of the private.
Well, at one time it was public, but they put the whole public in trust, and now they formed the private versus the public. So actually, when 1933 came around, your Republic, America, and common law and everything got put into trust. It's still being held in trust, but you can still access it through the in chambers, because that's where the substanding rights of the real man still exist, but hardly anybody gets in there. So once we merge the titles and terminate the trust, now the republic comes back.
Well, that'll be an exciting day. Now, could you kind of talk about when we merge roles? For example, we're obviously always going to qualify our signature from now on anything we sign as a grantor. And then if we get into a situation and we decide to merge, for example, can you be a grantor and a trustee, or can you only be, for example, a grantor and a beneficiary, or the only time the trust terminates is if you merge all three? That's or is there a combination? Is there fatal combinations that terminate the trust?
Well, you said three things there, and it's a yes to all three things. Yes, you can be grantor and trustee under certain situations, or you could be grantor and beneficiary under certain situations. And yes, when you merge the title into one entity, the trust terminates.
What about trustee and beneficiary? If they're one and the same party, would that terminate it?
Yes.
Okay, so if you had multiple beneficiaries, one of the beneficiaries could be trustee and beneficiary, or would you have to have multiple trustees and one beneficiary if there was, or would that terminate the trust if one of the trustees was the beneficiary as well, if you had multiple trustees?
Well, if you've got multiple, people, you have to take their rights and merge their rights. Are they holding equally, or are they holding in percentage?
And that comes into that question I asked earlier about the exact about the nature of exactly in that entry into Gilbert's about merging titles.
If they held equally, I think any single one would be able to merge the titles for the rest of them because they all hold equally. But if they're holding like each a share, then they would all have to come together and merge.
And I was looking at the word alienability, and then we have the word alien, and I was picking that out, trying to figure out where that might have originated from. Do you have any ideas on that?
No, my guess is as good as yours on that one.
Okay, I was just wondering if there was because really it's lienability is whether or not somebody can actually have their rights or their property transferred away from them, because that's what a lien does, obviously. I was just wondering if
probably a person who's transferred out of wherever he was, so he's an alien, a lien.
Okay,
it means transfer.
Desert Owl will probably have a good input on that, huh?
It could be he just transferred from one realm to another. Now they call him a lien.
One of the other things that I was looking at is, there's so many people dealing with different situations, whether it be that they don't have any existing court cases, or that they don't have, and what they want to do is they want to establish they're in
the best position, really in the best position, because they don't have anything pressing on them, and they can take the time to study this and get this down so that they know it like the back of their hand, and they don't have to be under the gun because I got to know it tomorrow.
Right, and that's obviously the first person. So then I think, in that situation, they're going to want to go ahead and utilize the Declaration of Independence to express, and then do the SS5 as grantor. But what I was wondering, maybe if you could put together like a chart from the people who have no issues to the people who have court cases to the people, or maybe the people who have mortgages but no foreclosure pending against them, to maybe the people who have a mortgage, and then everybody else who has an action in court, as far as maybe the way that they want to take action, just to get a kind of like a chart of how we would want to act based on where we're at.
That's basically what I was trying to do, is put together a model, and the same model applies to whatever situation that you got, because it's all a trust. Trust operates the same way. No matter what,
I was bringing that up,
all operates the same way.
The reason I was bringing that up is because sometimes when people are talking about, their mortgage note, they're bringing up doing the SS5, and, that's not the right thing to do. Or if they have a court case, maybe they're bringing up talking about doing the SS5, or no court cases.
Yeah, they're using it because they're thinking they have to bring it back into that Social Security account. No, you don't really have to. You can just treat the case solely as a trust.
Right, and what I was talking about maybe is if you could put together maybe a visual model for everybody to look at and say, okay, this is where I am, this is where I plug in order to get an idea where they're at, maybe like on the tree or something like that.
Well, they need to bring it back to the signature. Where was the signature on the existing trust? Where was it formed? Well, that's at the signature, at the signing. And usually you can get the signing, they get your signature by, say, a combination signature rights under debtor creditor because you fell silent or fell into a dishonor. Or you're the holder. You're the holder of that instrument. because you didn't do a return, proper way of returning it. So that they get you under that debtor-creditor thing, and then you're liable under that, but you're not expressing it to be a trust to begin with, and that signature is really how it all started. Maybe that OR bond that you signed, or that acceptance of that indictment, and you're holding that indictment because you never expressed it to be a trust. So therefore you fell silent, and they got it to be construed under the debtor-creditor, and therefore imposing on you an arrest on your property, whether that be the conscience or your man or your house.
Because the conscience of a man is trust, and because when there's no man, then they don't have any choice but to go after their gain of profit.
Right.
Yeah. Okay. So, for example, when you fail to qualify your signature on a mortgage note, and then you do your administrative process, and then your declaratory judgment, and then your NOI to get into chambers where you can bring in your creditor's bill and equity, at what point in that situation to claim trust and prove trust, because you don't have the note that you originally signed, and they haven't brought it forward. At what is the model you're going to use to claim and prove? Would it be the case if you filed against them? Huh?
Most people have some kind of a copy of the note that they signed because they gave you copies.
Oh, so a copy is just fine.
Yeah, because I'm the one who signed the note.
Okay, so that's all it takes is a copy to bring it into chambers. I was wondering if you had to have the original in order to claim.
Well, it would help. Yeah, I had the original, but trouble is you're not going to have the original. And the closest thing I would get would be, say, a certified copy. If I can't get a certified copy, well, then maybe I better attest that I got a copy because I was a signer on the note.
Then I can attest. Okay. I think that answers a lot of questions for a lot of people because, I understood the process right up to getting into chambers, but then to prove and claim, that's what our trust is going to be, is even a certified copy.
I would form a notice of a declaration, say, into the county, and put that on the UCC, form the 2 records to prove that I was the establishment as a grantor because I was the signer. And if anybody can rebut that, they'd have to, produce another note that was signed by somebody else. How would that happen if they can't even produce the note? Where is there evidence to rebut my claim? Produce it. Davila versus Shalala says that unless you produce a record, none exists.
And then once you claim and prove, once you're in chambers, then you could go ahead. And then I can claim myself as the beneficiary.
Yeah, if there hasn't been any rebuttals to my claim, then my claim stands. So now I have standing as grantor, say, beneficiary, and then I can come in with the prima facie case of the affidavit, and now that I make the claim against the trustee that he didn't make the disbursement, Court of Equity is going to assume that he's guilty, and he didn't. And they're going to treat him that way and ask him, when are you going to pay? Unless you got a record of a payment.
Because he didn't make the disbursement, and when he did make the disbursement, he's in breach.
Yeah,
guilty, right?
Mm-hmm.
Okay.
So now I could compel him not to breach the trust. Order him to take the payment.
And then you said the affidavit a moment ago. And what affidavit were you talking about specifically, so everybody has a good understanding when they hear this?
Well, my affidavit is going to stand as truth of the case is going to be on the private side in chambers. Otherwise, on the public side, an affidavit is nothing other than the lowest form of evidence that points to a competent fact witness that can be put on the stand, sworn in, and cross-examined.
So it's going to be an affidavit of truth.
Yeah, an affidavit in truth, put on the public side that's going to state that, I've got the right to make the claim. But then I could also put an affidavit on the public side, because what do? They just make a claim on a foreclosure, and they attach somebody's affidavit of assignment.
Wait a minute. Did you mean private in one context there and public in the other? Because you said public twice, so I'm a little confused. So we were talking about private, so you would put the affidavit of truth into the private.
Right. And also one of the... But it's going to be treated 2 different ways.
And then the one in the private, how would you treat it? Because it was a little confusing. So if you could tell us again the one in the private, how we would treat it.
The law of the case. The one in the public is going to be just pointing to a fact that there's a witness that needs to be put on the stand, say, for example, which would be me, because I'm making the claim. I'm making the claim as the beneficiary. But that's the lowest form of evidence in their realm in the public side of the court. It only points to somebody that's supposed to be getting on the stand and testifying and subject to cross-examination.
And what would they look at it as a higher form of evidence if we had the opportunity to bring it in the public side?
Well, I'm operating colorably on the public side under their rules and regulations and their stuff, but really I'm operating dually on the private side in chambers, and I got a simultaneous process running simultaneously. I got a colorable claim on the public side, which I'm stating that I'm beneficiary coming in, but yet really that's the whole thing that sets up the in-chambers proceedings, where my affidavit over there is going to be in a different realm and different law weight.
Now, once we get into chambers, is the only people that's going to be there is going to be, for example, me and the judge, or is the attorney for the plaintiff going to be in there too?
Possibly. It depends how you can set it up.
Because CCI, do I even want to reveal anything to the attorney for the plaintiff, or do I just want to go
really, the attorney is representing the other party, which privately I should have gave them all the documentation at one time. They should have had it. So, I could play it like, well, they've already got the documentation. There's really no need for them to be in the hearing. This is for judge's eyes only. But maybe they might object or something. The judge won't allow it that way. But that's okay. They already got the information anyway. But see, they don't hold any weight in chambers. They're fictions.
Oh, no conscience. They come in. They can't be recognized in chambers.
Right.
So they could sit there and basically, no matter what they say, the judge can't hear them, just like he can't hear me in open court.
Yes, the same way, the reverse, yes. Just the opposite, the mirror image of the... That's why they could never acknowledge the debt when we asked for a debt validation, because they would be stopping the prescription. So just like in chambers, they can't be heard, just like you can't be heard in the public side as a real man. Their fictions in chamber can't be heard, and your live man in public can't be heard. Mirror image backwards.
But I can be heard when I go in as the plaintiff, because I'm not going in as a real man. I'm going in as fiction, correct?
Right.
Claim, you mean.
You're going as a straw man, yeah.
Yeah, just to make sure everybody has a real clear understanding that that's how I'm going to go in. And when you're talking about going into the public, you're talking about to go in for causes of action, correct?
Right, causes of action that they can see that they're accustomed to seeing in their form according to their process and procedures.
But that's the only reason that I would go in there is for my causes of action. For example, as we talked about, unfair business practices, antitrust, and
set up a horrible case on the public side just so I can come into chambers on the private side and prove my case.
Okay. Well, what if, so you're talking about, for example, in a non-judicial state where I would have to file, because if they file against me, then I'll have to come in there, so I won't have to come in under my cause of action, but I can come in without a cause of action and just put in the NOI to get in the protective order just to get in the chambers in that situation, correct?
Okay, I didn't follow you there. Could you clarify that a little bit again?
What I was saying is that I was thinking that the only reason that I would be in court in the public side is if I, especially as a beneficiary on the witness stand, is if I had filed a cause of action, if I was the plaintiff that came in. But in Florida, for example, where we are, obviously, Florida is a judicial state when it comes to foreclosures, so I wouldn't even have to file. So I'm wondering, would I even be in on the witness stand?
I would come in as a counterclaim then on a judicial case, say like in Florida.
Right, that would be a counterclaim. So what you were talking about is if we were coming in as a plaintiff in a non-judicial state to get it into court, then we might be the beneficiary on the witness stand because we were the plaintiff, and we would file based on our cause of action. Correct?
Well, that works the same. You got to have a cause of. You got to bring in a case. So you got to start a case. You got to have some kind of independent action.
Right, but in Florida, for example, I wouldn't need to bring in the causes of action, so I wouldn't need to be on the witness stand as a beneficiary, for example. Well,
you may never get to trial and get on the witness stand. You're making a prima facie case, and they may settle, before, because all you want to do is get in chambers.
That's right. Yep. Well, as you said before, whatever I got to do to get in there, I'll do what I got to do.
Yeah, keep in mind that in chambers is the same as an in-camera hearing. They're synonymous.
Right. Yeah, I'm aware of that. Yeah. If anybody else wants to come on, feel free. And anybody else on the call with me, please.
Yeah, anybody else have a question? Press *6. Anyone else?
I'd get in there. Tim in Tucson, you were talking there about foreclosures, and I have some idea how I might do it. I want to pick up some of these foreclosures people want to walk away from them, and rolling it into a trust, I understand, is the best way to go. And now I would be the trustee on that new trust, but there is the matter of the old trust that's being dealt with.
Okay, the old trust would probably be incorporated in the new trust.
Okay.
If you bring an independent action against that through this new trust that you're forming with this independent action, it encompasses the old trust, say, because you're going to incorporate it in there and turn it all into trust residence by special deposit.
So it's workable then?
Yeah.
Timmy, sure, Don, I got something else I want to ask Christian about.
Please.
All right. If the Holy Spirit is so wonderful to us that we could get away from the fiat currency system, and we actually went back to a gold-backed currency system, because I doubt I mean, this would be in a situation where we're not actually handing gold to one another for currency, but we were to have actually gold certificates or silver certificates or some type of certificates for an intrinsically backed system. All this would continue to be just as valid because there still has to be trust that we can go to the bank and redeem.
There's still trust operating.
Yeah, because the only way that this isn't going to be an issue is if we actually hold the intrinsic value directly in our hand, correct?
Trust does not have to have a value.
No, what I'm getting at is the only reason that we would not want to utilize all this is because we actually hold the gold in our hand, because we don't have to trust that the piece of paper on our hand is worth something.
Right, but really, I kind of like the system the way it is. If they would allow us to utilize House Joint Resolution the way it was supposed to be meant to do, because really we have the ability to create as much money as we need to get us through any kind of crisis or situation that we could face, and then once that situation is abated, then relieve the debt, release it by the relief valve by doing the opposite on the other side, and bring it down to more manageable levels like it was always meant to function as. But the whole problem is they're not allowing us to do that. Due to some greedy people, they're not allowing us to seek the remedy and do the opposite, the set-off on the other side. The discharge on the public and the set-off on the private. The relief valve. Actually, that ledger sheet is nothing more than House Joint Resolution. You can pump up the public side, the discharge side, as much as you want to get you through any kind of emergency, but then you set it off on the other side, bringing the public side back down into levels that you can manage. So I kind of hate getting away from that because we have a perfect system, except it's being misused.
Well, I don't disagree with you on everything you just said, but they're talking about, for example, the Federal Reserve may go away. So if things were to change as far as the system that we currently are in, and I don't think they're accountable to anybody but themselves.
And they're not accountable to the people because they're functioning in a democracy. But I don't live in a democracy. I'm supposed to be living in a republic. But I got hypothecated into a democracy. I'm trying to get out just like everybody else.
And what I'm getting at, though, is even if they were to get rid of the Federal Reserve, unless we actually carry gold, then everything that we're talking about, and when it comes to trust, is still going to be valid because we still have to trust that that piece of paper has value, correct?
Right, yeah. You got to have faith and confidence in something there, yeah.
Because there's a lot of people talking about, well, what's going to happen? What's going to happen if they get rid of the Federal Reserve? Are we going to even be able to utilize all this?
Oh, yeah, it doesn't make any difference. What they put in trust is by special deposit. In other words, in kind in kind out. What did you put in 1933? Gold. That means you must get gold back out. If they try to give me some gold certificates, that's proof that they commingled the funds in their breach of trust. Now we got.
They're really in breach of trust when they sell gold-plated tungsten.
Okay, yeah. Well, we'll have to watch out for those. We got dishonest people, no matter whether in government or out of government.
Did you hear about that?
Yeah, yeah.
So, I mean, that's certainly a modern example.
By the tungsten-plated stuff, and they really hold the real gold still in trust for us? Don't know. But it won't make any difference to me because we're going to take the remainder from the termination of the straw man, and we're going to form that new trust by an order and have them put what was supposed to be there back in that new trust. So it really doesn't make any difference to me whether they absconded with the gold or not. I'm giving them room to save face here. Put it into that new trust for forming, and now generate some interest for me on the public side. Put it in that new LLC over there.
Now, when you say interest, let's make sure we use that in the right context. When you're saying interest, are you talking about like I have $100 and it's 6% interest? Or are you talking about interest because I actually have a stake in it?
Okay, on the one side it's because I got a stake in it, but on the other side it's $50.
So again, the duality of the public and the private, is that what you mean?
Right.
Okay.
Because the $50 they can recognize on the public side, but my interest is really on the private, which is the stake I got.
Okay.
One of those duality portal words, but I think all these words are really portaling on both sides in dual meanings. And they're playing this game, and they're causing havoc. It's the definition of legal fiction I keep going back to.
And then you read that first page on that document you were talking about with the word in it, the treatise, practical treatise on the law of trust, and then most people wouldn't even get through the first paragraph, much less read the book and understand what it means. So
yeah,
the havoc just continues because there's no true understanding of what's really going on.
Right. You got to have that decoder ring with it. But here's legal fiction. The last paragraph under Black's Law 8 that says legal fiction is the mask. That's the straw man that progress must wear to pass the faithful but bleary-eyed watchers of our ancient legal treasures. Now that's our unalienable rights. But though legal fictions are useful in thus mitigating or absorbing the shock of innovation, they work havoc. They work havoc in the form of intellectual confusion. What if this isn't intellectually confusing with this duality, public-private thing and the switching of the words and stuff? It really wreaks havoc with our intellect. But yet it's the face mask that you must wear to interface in to do commerce. Because you got to get those colorful titles that actually are representing the real thing held in the public-private. And you got to come by way via the public. And the only way you're going to interface in there as the private man, the real man, is by putting the face mask or the straw man in.
Do you know when that definition of legal fiction, what Black's that actually got first?
Yeah, that was actually quoting from like a 1819, I think it said.
Because it's not in the fourth.
Yeah, I don't think so. It was actually making a reference to the ancient law by, I forget, let me pull it up again here.
Because to hear that, I mean, it just it validates everything that you've been talking about.
Yeah, they're making reference to, this is by Morris R. Cohen, The Law and the Social Order, 1933. And the paragraph above that is by Henry S. Maine, Ancient Law. Now that's 1901, and you ought to read that one. Get Ancient Law by Henry S. Maine and read that. You're going to be shocked.
Is that something we can find on Google Books as well?
Probably. I don't know if I got it there or not, but you could try.
Is that Ancient Law by Henry S. Maine?
Yes. Mm-hmm. I did a show passed on that one, and it goes back into Roman law and the what's the term that they used? Capitis diminutitu. They're diminishing your status under Roman law by the capitalization of your name. Capitis diminutitu. Look that up, Black's Law.
I wonder if it's in the fourth. I'll look it up right now and see if I have it in here. Unless you already know if it's in there.
No, I don't. Not on the fourth. I got the fourth revised. It's almost like they published this stuff in these later editions in the Blacks, so that it's already been posted in public knowledge of what they're doing. And it's like if you don't read these, then it's your own downfall because they've given you public notice. Yeah, it's voluntary ignorance.
I got capitis diminutio.
Well, what's the definition of that?
In Roman law, a diminishing or abridgment of personality, a loss or curtailment of a man's status or aggregate of legal attributes and qualifications.
By capitis, and capitis is capital, capitalization. When they capitalized your name, they diminished your status.
And it says capitis diminutio maxima, the highest or most comprehensive loss of status. This occurs when a man's condition was changed from one of freedom to one of bondage when he became a slave. It swept away with it all rights of citizenship and all family rights.
Right, and they're doing that by prescription. through a length of time that you didn't make the claim, and therefore you're going to lose the right, you're going to lose the claim.
One of the things that jump out at me there is, and all family rights. What do they mean by that, Christian?
All family rights?
Yeah.
Familial. Look that up.
Wow, family has quite a long. The word family has 1, 2, 3, 4 pages in blacks. Yeah. Familia, a household, the body of household servants, a quantity of land, otherwise called mansa, sufficient to maintain one family. Roman law, a household, a family, on the composition of the Roman family, on the composition of the Roman family. Okay. So it says it. So under Capitis Diminutio Maxima, it said it swept away with it all rights of citizenship and all family rights. So it says familia, a household, which means it swept away a household, the body of household servants. If it swept away the servants, the quantity of land, and mansa, which is sufficient to maintain one's family.
Right. So by Roman law, they've taken and diminished your status and created this legal fiction, and everything has been really a trust because a legal fiction is a trust. It's a constructive trust.
So when they capitalize your name,
they were creating a trust.
We're creating a trust, and and it's really an agenda to take your household, the body or your household servants, your quantity of land, and what's sufficient to maintain your family.
Yeah, seizing your assets. It's the vacuum cleaner that sucks all your assets from you. It says constructive trust, an equitable remedy, there it is, equity again, that the court imposes against one who has obtained property by wrongdoing. Let's see where else it says in here. Where
are you in Gilbert's now?
No, I'm under Black's Law 8, looking under constructive trusts.
So, boy, for people that want to keep their head in the sand and just want to continue on and not really pay attention, they get hit with this, and it's just like a truck running you over.
Really, yeah. I mean, there's too many grains of sand, and you keep piling the grains of sand, the evidence up, and next thing you know, you got a mountain. And for somebody to deny the mountain of sand is like, you got to be a fool. You got to be totally brain dead.
There's no way that I could ever go into that public court again, Christian. There's no way.
Well, I think if I know how to operate under the straw man, the puppet, yeah, why would you be afraid to go into court?
Well, if you know how to operate. But you know what somebody likened it to me? They said it's like going into a completely dark room, naked, and there's broken glass all over the floor. And it's
okay,
also
well, I like to a minefield. But, in every minefield, there is a safe passage by a secret path. If I know the secret path, I don't get blown up.
Yeah. But just in reading what I just did, those definitions, and looking at what the reason that they developed the capital letter name, they
is for the purpose of them getting you. Yep.
Yeah, that's the real purpose behind it. There's no other reason. So when I look at my driver's license and I see that on there, I feel a whole lot differently now when I look at that.
But the reason, or let's put the remedy to defeat them is really to agree with them, create no controversy, and then later on get into position and change it.
So that would be, for example, if they level the charge against you, you could say, I'm here to plead guilty to the facts.
Yes, right, because if there's no controversy, there's no case. And now I can go into chambers and tell you why, Judge, that I, as the trustee, didn't make the payment by legal means. And my legal means we're under discretionary trust, and I have discretion as the trustee to withhold because the beneficiary is bankrupt, insolvent.
Now, if the judge says to you, what facts are you pleading guilty to?
Well, I'm pleading, I'm going to agree with you that I am the trustee. I'm going to agree with you that I did not make a payment. So if it's operating by trust, and that's, I'm in there as a trustee defendant because I didn't make the payment, all right, I'm going to agree that I'm the trustee, and I'm going to agree that I didn't make the payment. Now there's no controversy. Now
that makes perfect sense. Why, when you go to jail,
why I didn't make the payment. And while I'm in there, after I explain to him why, because of the discretionary trust, now, oh, by the way, Your Honor, here is a non-negotiable private instrument for the payment, and now let me pay that so that the bankrupt beneficiary is no longer bankrupt, and then I can disperse the total funds. Make him solvent again, so now I can fulfill the purpose. I'm in a win-win situation. Whether I want to play beneficiary or whether I'm going to play defendant or trustee, either way. Either way, we're in a win-win situation. And here we were wearing the slippers all along, just like Dorothy was in the movie. And all we had to do was click our heels together 3 times, write title and interest in trust, and we're back in Kansas again, back home.
So, for example, I have a case that I was involved in, and I was acquitted of back in the beginning of November. But I was still had a few things that were held withheld adjudication on, so they could get the statutory fine out of me.
Right. So they could still keep funds running in the background, the bid bond, payments bond, and performance bond.
So I can turn them into a trust.
Yeah. Just get the main trust, the whole case, and that takes care of all the proceeds that are attached to it, and put it all in special deposit. And if the debt is paid, or order it to be paid, whatever's left, tell them to give me the disbursement back, and you get the funds.
So I can walk out of there with a check.
No, but what you do with that check, is that going to be the temptation on the debt side? No, you put that check back in under special deposit, back on the private side, and then tell them to generate you interest from that, or else you're back in the same situation.
Okay. And at this point, what would I do? Just send an NOI to the judge's chambers?
Well, yeah, but ultimately I like to be into the IRS, because the judge is going to have to listen to the IRS.
The problem is, though, that the fines are due by April, the end of April.
Okay, well then play the court route until you can get, say, the IRS to come around and be your big brother and tell them they got to close the account.
So what? Maybe go ask for some more time to pay the fine until we can get the IMF file changed over.
Yeah, you can do that.
What other choice would you think I have?
Do an acknowledgement of the debt. That puts an estoppel because of the agreement, no controversy, and then put the offer in for the settlement. Or, excuse me, not the offer, the order in for the settlement. Come in and make sure that you got a special deposit, claiming all those bonds in the background. Tell them to apply that towards the, convert that to funds and make the settlement. Close and settle that case.
So I can do that before the IRS file, the IMF is changed over.
Yeah, and then I can give that information to the IRS and tell them, hey, check it out and make sure everything's all closed here.
Okay, so how would I do an acknowledgement of the debt at this point? Would I do that directly to the court?
Yeah, just put an acknowledgement of the debt.
So it would be a notice, and then I would... would it be
just like Black's Law says, acknowledgement of debt. That's the title of the document. That's the title of the thing.
Okay. And then as a real man, I would acknowledge it?
Well, you're through the straw man, you would, yeah.
Okay. And then, so send that directly to the judge's chambers, or send that to his assistant to get a hearing in open court?
Send the acknowledgement of the debt?
Yeah.
Yeah, that would have to be on the public side.
Okay. So he's going to say, okay, well, you already acknowledged the debt the day that I assigned it to you, so what are we here for, right?
All right, but now the bonds in the background, that's where you need to discuss that in chambers. That encompasses that, and that's, if you're going to disperse that funds and convert that to cash and settle everything on the background.
So I would do the acknowledgement so I could get a hearing, so I could go ahead and submit the NOI.
Right.
To get in the chambers.
Yeah, to get your SOI in chambers.
And then the SOI would be the case that I would turn into a trust, and I would do that on a UCC 1 and 3, correct?
Yeah, that would be the special deposit.
Okay. And that's, so those are the documents, the UCC 1 and UCC 3, that specifically would be the SOI, correct?
Yeah, along with the UCC 1 in the counties also.
And so I would file it to the public record with the UCC 1?
Yeah, first I got to claim it if I don't have a title. I got to create a title. But if I got a title, which is the case, it's already, I don't have to create another title. It is the title. The case number is the title. Claim it on a UCC 1. Now it's mine. Create the 2 witnesses, the UCC 1 and the county recorder. Now I've claimed it. Now we want to, and it's mine. Now we're going to move it. We're going to sign it. We're going to transfer it. We're going to make a special deposit under UCC 3. Do the UCC 3, pull that out certified. That's 1 record. Do the county again, pull that out. That's 2 records. Now you got 2 records to prove that you did the 3 transfer, the formation of the trust, making a special deposit, and you got facts that you could back up on the 1 that you claimed and was your property to move it. So now you transferred trust property. That's when the trust was formed. And you got the proof to prove that you formed a trust because you transferred property to a trustee. So there was a document we put out there, notice of the claim, that was meant for the UCC1, but then you changed the wording, and you only changed really one word in that notice that was in the county. Instead of claim, you put transfer, and then you put that same verbiage on the UCC3 in the collateral block, because now you're just making a transfer. So exact words, it was only like 3 lines. Exact words was, claim, but we changed claim from the 1 to put it on the 3. We changed it to transfer on the 3. Same verbiage, though.
And what verbiage are we talking about here?
The notice. The notice and the verbiage that goes in the collateral block 4.
Right, but I don't have a model for that verbiage that I'm going to need, so I'm wondering if you can tell me what the model of that is.
Yeah, I'll pull it up here. It's really simple.
That, unless you want to email it to me.
No, it's real simple. I just put it on here. It's not. Right. It's only 3 lines long.
All right. And while you're pulling that up, the judge that I had, they said, "Oh, he doesn't do in-chamber hearings."
Yeah, right. Is the bear crap in the woods?
He's going to do one for me.
If there's a protective order on this stuff establishing trade secret information, then we got to have an in-camera hearing. They look at your case and say, "Well, you've got nothing to put into an in-camera hearing with," and they may be right because you haven't established CCI information by putting in a protective order. So this is just notice right across the top, and this is what goes into the county. So this is actual constructive public notice by grantor as owner and holder of all right, title, and interest with the non-negotiable instrument claim number, and then your RA number goes in there, -US, with all attachments and proceeds therefrom as being held in the private. That's it. And then if there's any information regarding this that needs to be gleaned, please contact the grantor at the address below. And then signed by grantor.
And that's the notice that goes into the county, but that's also what goes on the UCC1?
Yes, put that in collateral block 4 in the UCC1.
And there's just one thing that changes on that collateral block 4 on UCC1, one word on that, right?
Yeah, you change claim from claim, the non-negotiable claim number RA, you change claim, because now you're making a transfer, you change claim to transfer. So the right, title, and the interest with a non-negotiable instrument transferred by number RA such and that with all attachments, proceeds therefrom, and then you're going to do a special deposit by transfer to the trustee on a UCC3. So this goes into the county, pull this out certified, there's your notice, that's one record. Put this verbiage in the UCC1 collateral block 4 on the 3 for the notice, or I mean for the transfer. Do the same thing on the 1, but change the wording back to the claim on the 1. Pull that out certified. Now there's your there's your 2 witnesses right there. There's your proof to prove the claim that you formed a trust because you did a transfer of property on the 3. And anytime you have a present transfer of trust res property to the trustee, you've got a trust. As long as you got intent, purpose, and other parties established, because your specific res, you're naming on with the RA number, and whatever is in the case, put all that documentation and stuff, put that in the footnotes of any documents that you put in the case, and that indicates it's all the same thing. So anything with that RA number is encompassed in that case. And you can reference the RA number to be case number such and such and such. So connect it all together, like Tinker Toys.
And that RA number I'm going to reserve specifically for this case. Any other case, I'll use a different RA number, correct?
Different RA number, yeah. Mm-hmm. Different trust.
Okay. Okay. And, well, I got to do that just because I can't see paying them that $468 or whatever. And it would be a great opportunity for me to put this technology to work to get into an in-camera hearing and have a real-world situation. Now, if I do get in the in-camera hearing and for some reason it doesn't go the way that I want to, can I always go back and express again and get another hearing?
Yeah, probably with some new trust res.
Okay, and what would be new trust res?
Any new motions and stuff into the court, you could turn them into special deposits also and turn them into another trust.
So then at that point we could just we could figure out a motion to do to because maybe a motion that I can't pay the fine because there's no lawful money?
In chambers, yeah, you could say that kind of stuff, yeah.
Okay, so that would be another motion to get back into chambers.
Yeah, you could try that.
Okay, all right. Yeah. All right, cool. I'm proud to say that I'm going to utilize your technology, Christian, and I can't wait to report back to you.
Okay. I think you're going to find out when you get into chambers and that judge doesn't have the robe on, they're going to be much more on your side because they're not going to be on the side of the fictions in there.
Now, what's the chances of me recovering the $3,000 I paid out to the lawyer for the trial that I had? Do you know of any method to do that?
Well, if you got the bonds that are in the background attached to the case, as all the derivatives from there, you're going to get the disbursement from that. So if that's going under an assumption that that's say $4 million on the county and $40 million for the state and $400 million for the federal, per count, so you're talking about a lot of money.
Well, these were misdemeanors. Is it that level?
Yeah, that's what's really operating the courts, because your value, your case on the public side probably doesn't pay the judge's, lunch bill.
Okay. So what you're saying is I could get the disbursement for this $400 million?
Yeah, for all the bonds that are in the background, yeah. All the derivatives attached to this case. All the bid bonds, performance bonds, and payment bonds.
Okay, so if I'm
all attachments and proceeds therefrom, this is going to encompass the whole thing, everything that's attached.
And if I'm able, so I'm going to go into chambers, and the case is going to be turned into a trust. What procedure do I go in to get those funds into my hands?
You're going to go in and put the order for the settlement, just like we discussed on the show for taking over the main account back. It's the same model. You're going to put in the order for the discharge on the one side and the order for the set-off on the other side. You're going to put in the order to merge the titles. Once the titles are merged, then there is no trust. The trustee has to give you the disbursement because there's no trust. He becomes personally liable because there's no trust for protection for him. If he doesn't disperse the funds, he becomes personally liable.
And since I haven't changed over my individual master file, if I increase the national debt by $400 million, I want to do that before I change over my individual master file, because that's exactly what I'm doing by getting disbursement. It's getting put on the debt, right?
Well, if they give you debt titles back, you're not going to put them back in the circulation in the public. You're going to tell them, hey, put the remainder, after I've done the merging of the titles, if there's anything left over there, put that in this new trust I'm going to establish. And then start generating some interest on the public side for that, and then say a new LLC or something.
So, for example, if I generate some interest 10% at $400 million, then I can write a check off of that 10%? Is that what you're saying?
Yeah, if you could get the interest in the LLC, yeah, you might be able to do it that way. But what may hold you up is they may seize the funds anyway because you're still effectively connected in as a debtor because that original master file might not be, corrected. Same reason why they're claiming or freezing up the OID refunds.
Okay, so if they were to seize the funds, and they may not, right? As we've talked about, that there's spotty remedy, right?
Yeah, right.
Okay, and if they were to seize the funds, then the chance of me recovering my $3,000 that I paid out to that lawyer, then I'll lose that chance, correct?
Possibly so, yeah.
Okay, but
trouble is, put that in with the discharge, and that should take care of it, though, because that went into special deposit. His fees and all that stuff should be discharged once you do the trust. Once you merge the title, terminate the trust.
Well, the lawyer's already been paid.
What's the outstanding fee again? You said $3,000 on what?
It's not outstanding. I paid him in FRNs.
Okay, but didn't you say there was something you owed yet?
Yeah, $468 in statutory fines.
Oh, okay. Well, that's the part of the trust deposit. That should be taken care of with this trust. So if you don't get any funds back, that's still taken care of.
Right, I understand that, but I'm just wondering how I can get my $3,000 back. My hands back on that $3,000.
Okay. Well, really, you didn't give them anything. You gave them Federal Reserve notes. They have no value.
Yeah, well, they got value right now, Christian.
Hello, Christian.
Hey, how you doing?
Hey, I just wanted to interject because I've just found a book, and I think it'll bring a lot of help to everyone. It's called Agency and Trusts for Payments of Debts Under Private Arrangement.
Oh yeah, sounds good. Sounds interesting.
I think it'll help, both ways, like for doing special deposits and for, not only for us paying debts, for other people paying our debts back.
Does it talk about special deposits in there, trust deposits?
Do you know what? I've only just found it. I found it on archive.org, but it does talk about, let me see, in the contents it says about, here we go, shortly will be published prescription and limitation of time in relation to real property. But
did you say prescription or proscription?
Prescription, that was.
Prescription, huh?
Yep.
Read that sentence again.
This is a soon-to-be published book. This book was published in 1868, and the soon-to-be published book is the prescription and limitation of time in relation to real property of the Crown, the Duke of Cornwall, and private persons.
Remember, prescription was the extinguishment of the right due to an extended period of time.
Yep. This book is printed at number 3 Chancery Lane, which is the same street as the public trustee, the official solicitor in England.
Ah.
So I'll just go to the contents pages because it says, number 1, the kinds of instruments to be considered for payment, I think it is. Let me just see, because it just cuts off there. Agency and trusts, yeah, of instruments in general made for discharging the debts of the makers.
What year is the publication on that?
The book?
Yeah.
Did I say 1868, was it?
1868, okay. So this is before 1933, so we're talking real sub.
Yeah, if you go to, or if anyone goes to archive.org and they type in trusts, and you're just going to get tons of pages and it's all downloadable. So my thinking from what the gentleman was saying and how you attempting to describe how to, get debt settled, then this book, Agency and Trusts for Payment of Debts Under Private Arrangement by William Brown, Esquire, of Gray's Inn, barrister at law.
Can you give us that title real slow?
Yeah.
What's the title of it again?
Agency and Trusts for Payment of Debt Under Private Arrangement.
That's also on Google Books.
It is.
Okay, remember a BOE in today is going to be under debtor-creditor, so you can't really use a negotiable instrument of any kind. But what is likened to the BOE, although it's not a BOE, is really under Section 159 on page 41, which you read earlier, I believe, about the merger of the title, because a merger of title acts like a BOE in exchanging the bills. You're merging the titles. You're merging the two bills together, the debt bill and the asset bill. And when you merge the two bills, it's the same as being a BOE or exchanging the bills, but under trust, you're merging it. Under debtor-creditor, you use a BOE. So how you do the payment under trust is you merge titles. Under debtor-creditor, you're at a BOE.
Christian?
Yeah.
Listen to Chapter 2. This is the title for Chapter 2. Of instruments for the payment of debts made without the privity of or any communication with any creditor. How these instruments are viewed as Section 3. It's only a short book. It's only 100 and something pages, but wow, jam-packed.
Title of it again?
Agency and Trusts. Oh, you're testing me now. Agency and Trusts for Payment of Debt Under Private Arrangement. And Chapter 2, without the privity or any communication of the creditor. That's crazy. And it's by William Brown, Esquire.
Well, we'll have to look into it a little more, yeah.
Yeah, definitely, yeah. Okay. I just wanted to jump in with that one because I felt it was quite apt.
It's 100 and something pages, because the one I found on Google Books looks like about 54.
Sorry?
You broke up.
You said it 10 something pages?
I thought so, yeah.
But the one I found on Google Books is 54 pages.
Sorry, 54, yeah. I've been looking at hundreds of trust books there on archive.org, so forgive me on that one. Revocability of these instruments as to creditors, revocability of these instruments as between the parties, not creditors. It's got some nice stuff in there. Nature of the instrument as respects surplus after creditors entitled are satisfied. Surplus. Requirements from creditors to entitle them to benefits. Chapter 3 of instruments for the payment of debts made with the privity or on communication with the creditor. And then Chapter 4 of instruments for the payment of debts made without the privity of, but afterwards communicated to and assented to or adopted by the creditors. Creditor a party to and executing the deed. It says that the deed is an instrument of payment. I was reading in the introduction.
Yeah, I've heard that before also.
But I've literally just found this book, like as you were both talking, you know. So yeah, that's me.
Thanks, Pete.
Welcome.
Okay, anybody else have a question or a closing comment? It's getting kind of late. It's 1 o'clock our time, so.
I just want to say, Christian, thank you so much for tying it all together tonight when you were talking in the beginning of the call. It really helped clear up so much to connect all the dots.
Okay, great.
Can I just say one more thing there I've just found?
Yeah, go ahead, Pete. Go ahead.
Yeah, there's a table of cases cited. So, you know, you can look into the history of the cases and see how them private arrangements were dealt with. It's all in England, though, but I'm sure that, you know, must be the same in America somehow.
Yeah, I don't think anything's really the same stuff. Yeah, it's got to be the same stuff. Yep.
Yeah.
All right. Well, I'm going to call it a night. So today is Tuesday. We'll see everybody tomorrow night at the talk show call at 724-444-7474. Excuse me, 7444, and the PIN number is 41875. And again, the number is 724-444-7444. PIN number 41875, and that's at 8 p.m. Eastern Time. So, yes, attach the disclosure to this recording, so in case I didn't read it because I don't feel like going through it all, but anyway, it's attached here by reference. So I'll see you tomorrow night. If not, I'll catch you on the Saturday call. Check out my website at movingtitles.com for, you know, any new information. I'll be updating that as fast as I can. So check that, you know, a couple times, maybe a week. You know, there might be stuff in there. So I'll see you all later.
Christian,
yeah, go ahead.
This is the Tuesday night call number from now on, right, Christian?
Yeah, the Tuesday night call number, we had some mix-ups there. I think it was basically on my mistake. So it won't be the Share Plus number that was given. It will be that 712 number.
The 432-0075?
Yeah, 07, yeah, that number, yep.
With the PIN 917030?
Yeah, because that one, I guess, is accessible through Skype, so it won't be charged for that.
Great. And then you're still on 712-432-8773 for Saturday?
Yes, that one won't change.
Okay.
All right, night all. Have a great week. Talk to you next time. Praise the Lord.